For judgment, item number 1, CRLA 49 of 2004.
The appeal is accordingly dismissed. No order system. The bail bonds of the appellant stand cancelled. They are directed to surrender forthwith.
One mention. For physical mention, Mr. Sanjeev Mohanty.
April Lordship. A batch matter has been disposed of this honorable court.
Item number 2.
Yes, Mr. Acharya.
Yes, let us short question. There is an export and import policy which is formulated by the Ministry of Commerce that your lordship would find it at Annexure 2. But they granted certain incentives like zero custom duty. Your lordship may kindly turn to page 62 of my brief. Let that paragraph, because it's a very voluminous document, I only annexed the relevant portion from para 5. This for a period of 5 years from commencing from 1st April 2015. That first page and the other some pages I have handed over and passed, and I think we sent it by mail to your lordship. But this is under section 5 of the Foreign Trade Development and Regulation Act 1992 for a period of 5 years. That if your lordship goes to that notification of 1st April, let this Director General of Foreign Trade, because he is the empowered authority under section 5. May I read section 5 of the Foreign Trade Development and Regulation Act? Export and import policy. It's a statutory policy, by subordinate legislation. The central government may from time to time formulate and announce by notification in the official gazette the export and import policy, and may also in the like manner amend that policy. So the power to formulate and amend is all vested with the Director General of Foreign Trade, which is the nodal agency of under the Ministry of Commerce. They granted this incentive, this zero customs duty, which was valid first from 31st March 2018, extendable up to June 2022. The latest notification also I passed on. We have annexed up to 31st March that your lordship would find the ministry's notification at annexure 17. One second. Annexure 17 at 134.
Yes.
That is the latest notification in exercise of power conferred by section 5 of the Foreign Trade Development and Regulation Act so and so, read with paragraph 1.02 of the Foreign Trade Policy 1520, 2015-20 financial year, that has been extended up to that extension later. I'll show it. But we are covered under this service provider. I am concerned with para 5.01a, date 39/21, as appearing in the second sentence is substituted by 31/3/2022. But the latest is June 2022. But this para 5.01, your lordship may kindly turn to page 62. This zero customs duty, they say, I am entitled to it being a service provider, but I am covered, your lordship, 5.02 coverage. The next page, 63. EPCG scheme covers manufacturer shall be fulfilled through physical exports and the export proceeds realized in freely convertible currency. However, the following categories of supplies shall also be counted towards fulfillment of export obligation. Lord, your lordship may, what is that? That has been defined. What is export? Payments received in rupees terms from services such as specified in paragraph 5.04 of the foreign trade policy. Lord, I am covered under this. There is no dispute. Lord, what they do it in 2017, the finance department, Lord, in contrary to the foreign trade policy formulated by the commerce ministry, comes out with this notification. Lord, that it is not applicable. They can't. Lord, one department of the government in right hand extends and the other department takes it away. They cannot. And that is purportedly under section 25 of the Customs Act. Lord, there has to be a harmonious construction between the two. That is what exactly, Lord, the 70.
So what is given by one hand is taken away by the other.
By the other hand, how can you do it?
All right, we just issue notice. We'll just issue.
In this case also, because I have got the authorization for the current year, they are charging. So Lordship may say that we may do it without.
Subject to the outcome. All right. Subject to the outcome. You see, notice. Mr.
extra comment
Shimaka
can be
accepts notice for whom are you accepting notice, sir?
I'll receive for 2, 3, 4, 5.
2, 3, 4, and 5. Mr. Padi for opposite party number 1. Replies to be filed within 8 weeks, rejoined up to the next day. It is clarified that in the IA 18480 of 2021, it's clarified that all payments made by the petitioner towards GST cess, is it?
Yes, Lord.
In terms of Annexure 1 to the writ petition.
Including interest, Lord, because they are charging interest.
GST sent, yeah. All payments made towards integrated tax, GST cess, and interest in terms of Annexure 1 to the writ petition will be subject to the outcome of the writ petition. The IA is disposed of.
Your Lordship may issue notice in the IA because in the current also, my Lord, I am authorized. I have the authorization to do.
No, so it's going to be subject to the outcome, sir. There's no need for notice.
So your Lordship may fix a date so that because it's very huge amount.
14 September.
Extra copy.
Extra copies.
Can it be
3, 4, 5.
Well, it's okay, sir. That's okay. They'll take their time to file replies.
Supplementary list item number 3.
May I please, Your Lords? The petition in this case, my Lord, as approached this honorable court, against the notice under 148 of the IT Act, under Annexure 3, page 17, that is for the assessment 1516, or notice dated 31st March.
Additional CIT.
Additional CIT. It should be
covered. Ambika and Street. All right. Since the impugn notice was issued by the additional CIT, impugn notice dated 31st March 2021 is issued by the additional CIT and not the CIT. Following the decision of this court in Ambika Iron and Steel, the impugn notice is squashed. Just say
Challenge the order.
Where's the subsequent order is there?
Order is there, Lord. Next page.
The consequent order
I'm favoring you.
dated 30th March 2022 is also hereby quashed. Right.
Supplementary list for orders item number 4.
May I please, my lords?
Yes.
My lords, I'm appearing behalf Mrs. Bharti Das. This case is infructuous. Please,
All
not
right.
to
Counsel for the appellant states that this is infructuous. It's disposed of as such. All right.
obliged.
It's all right. Reconstruction of first page is allowed. It's straightforward.
Supplementary list item number 5.
None appears dismissed from opposition. All right. The memo for withdrawal is taken on record. The writ petition is dismissed in terms thereof.
Supplementary
Dismissal
list,
is withdrawn in terms thereof.
supplementary list item number 6.
None appears dismissed from opposition. Oh, this is a 2022 matter.
My Lord, item 6, my Lord. So, my Lord, public litigation, in the case, my Lord, there is theft of mining minerals. We made a representation to the secretary, and still it is, they are not investigating, they are not taking action over it.
All right.
Yes, mobilize, collector. Yes, we'll make a
representation before the collector of police partner.
I will make a representation.
Counsel, the petitioner seeks leave to withdraw the present petition to make a representation to the collector. Rayagada district. If such application is made,
OP3.
if such representation is made not later than 1st July 2022, the collector will, after hearing the petitioners, pass a reasoned order thereon. Not later than September 2022 and communicate the decision to the petitioners not later than 12th September 2022.
Obliged.
The court clarifies it does not express any view of the matter. The petition is disposed of.
Supplementary item note 7.
Item number 7, state is the petitioner. These are all matters challenging the order of the
My lord,
No. Which one?
Item 7 supplementary.
my lord,
7 promotion. Your defects are not removed, sir.
my lord, annexure 1 is
Defects.
defect, my lord. The state is not a party, that's why I am not serve copy.
No, but
The district judge is a party, my lord.
Party, so he has to solve the problem.
where is Mr. Mudli is supposed to?
Is not.
All right, notice Mr. Mudli,
Right that he should solve copy on Mr.
complete copy be served on Mr. Mudli. Reply be filed within 8 weeks, rejoined of the next day. 20th September, 20 September.
My lord, today opposite party joined the selected person. Those were illegally selected, my lord. I have filed a
Which
miss case,
opposite
my
party,
lord.
sir?
My lord,
Which opposite party?
district judge, my lord. District judge Puri, my lord. I am a ST candidate. There is 23 vacant posts. Out of 23
In
vacancies,
this,
18 already.
IA 5983, you
Yes.
say all promotions made in the meanwhile shall be subject to the outcome of the present petition.
Oblige, my lord.
All right.
Supplementary list item number 8.
Oblige, my lord.
All promotions made to the post of head clerk of grade 2 shall be subject to the
Oblige, my lord.
outcome of the petition.
This matter I have mentioned. All these matters are matters I pray that let it be posted.
Item 8, actually, there are 4 items, my lord. If your lordship looks at
Yes.
3 different RP cases, actually.
All right.
Date chart and entire, it has to be done, my lord.
All right. At the request of counsel for the parties. 26 September.
26th September.
Yeah.
Supplementary list item number 9.
But item 9, actually, I am appearing with your lordship's leave, my lord.
Yes.
So this matter, if your lordship looks, relates to the demand of warfares and stacking charges.
Right.
Railway siding. But if your lordship, there's a 2 crores 88 lakhs was the demand. Subsequently, if your lordship tells to pay us 45, that has been reduced to 552 lakhs 26,000.
Right.
But in the meantime, what has happened? Pays 48. Let me kindly see.
Name change.
Yes, man, it has been taken over by that dispute resolution process. Malad. In the meantime, it has been done. And those batch of cases that any demand relating to before the finalization of the proceeding, the dispute resolution process has to be nullified because if your lordship decision, Malad, if your lordship Ghanshyam Mishra's case and 2 other cases, your lordship.
Ghanshyam Mishra and all of that.
Yes, but now those matters are listed today before Justice Jaswant Singh and
Oh, I see.
they are.
We can list it along with that.
Yes, it should be listed along with that. That is item 40 actually in that case.
All right. I'll simply say list along with.
Yeah, that should be listed along this.
What is the writ petition number there?
Those batch of writ applications are WPC 1189 of 2015 and batch. I'm sorry.
Along with writ petitions.
I'm sorry, just a minute, sir. I'm sorry. That is WPC. That number is I'm giving that. 13730 of 2021
13730 2021 and batch.
and the batch.
Before the appropriate batch. Right.
But I have also filed an amendment application because of the change of the name. That may also come along with that.
All right. This will all come together only.
Supplementary list item number 10.
My lord, item number 10 and 12. 1 minute for just. Item number 10 and 12. Mr. Muduli is conducting this case. He is on leave today only.
Oh.
I pray that let it be posted to tomorrow because he has
It won't
filed
get
all
over,
the-
sir. It won't get over.
Let it.
12, I think rejoinder is not filed. Night on 12.
Regender, I have already filed.
12.
No, 10. He is for 10.
Acha.
I am in item 10, Lordship.
All right. You say an item 10, you say Mr. Muduli is in some difficulty today. Mr. Muduli appearing for the opposite party is in some difficulty today. 5th September. Pardon? 5th September.
Lordship, he succeeded throughout, Lordship. For last 2 years, now he has retired, Lordship. Lordship, let it come next week anytime, Lordship.
Only difficulty, sir, this is the last week before the vacation.
Lordship, he is prostate for last.
So yesterday we got up at 4:45. Do you see the number of cases on the board today? It's difficult, sir. That's why.
Lordship,
This will take some time.
Lordship, I pray, Lordship, since 8, 10 times it has been adjourned for their court. Lordship, let it some early date, Lordship.
So we'll try hard, but what will happen is
I
if you give
pray,
an
my
early.
Lord. Only I can
I
pray,
know.
my Lord.
My request to you is, if I give you an early date, it may not be taken up on that. Then you will get even more frustrated. You will say, sir, one more adjournment. That's only difficult. But you don't mind. We'll give you a date, early date, but it may not be taken up on that.
Great difficulty it is listed today. Lordship.
There's no difficulty, sir. In my court, there's no difficulty. It's only that Mr. Mudali is not present today. Otherwise, you would have taken it today.
Anytime, Lordship, in June. Anytime in June. Anytime. Last part of the.
You take your chance. Sir, I'm just telling you what will happen. I know, and because this is my own board. I should
That's
know.
it, I know.
To satisfy you, we'll give an early date. You can be sure that on that day in June, you'll be saying the same thing.
Lordship,
to
I am
satisfy
facing
you,
for last 2
you can
years,
go
I am
back. You can return today very happy that I persuaded the Chief Justice to give me an early date. He gave me an early date. That is the only result of today's hearing.
Lordship, that pleasure I
All
will
right.
be-
Let's
that
get
pleasure
that
I will be given. Lordship, that pleasure.
Problem. Your pleasure is the most important thing, not the conducting of the case. 23rd June.
My grateful, my Lord. Grateful, my.
Supplementary list item 11.
In item 11, supplementary list. Item 11, my lord, on 15th of February, my lord has issued notice in the matter, but till that no counter has been filed.
We need some time to file.
4 and 5.
I pray my senior to submit a copy of the counter.
Yes, file counter for.
OP 4 and 5.
Oh, for Vedant.
I pray some time to go through the counter, my lord.
All right, counter affidavit of opposite parties 4 and 5 have been handed over. Rejoined for the next date. 7th September.
Oh, bless me.
Supplementary list item 12.
Item 12, same thing, Mr. Muduli is.
Yeah, Mr. Mudali.
But rejoinder has to be filed by them. Because
Who's for the petitioner?
My lord, I am appearing for the petitioner. My
All
lord,
right.
the matter may be passed over.
No, you don't want file rejoinder?
Yes, my lord. Yes, my lord.
Rejoinder be filed the next date.
Obliged.
28th September.
Supplementary list item 13.
My lord, we received a copy of the counter from the state in this PIL matter. Lordship, may kindly grant me some time to file a rejoinder, my lord.
The rejoinder be filed the next date.
For that.
28th September.
my lord, date is 5th September.
28 September. Supplementary list item 14.
Your Lordship had extensively heard this matter on the last occasion. And
Lordship, I have been engaged by RERA, so I have filed my affidavit, my lord, pursuant to your Lordship's last order. I have not served copies on my lawn and friends. I'll
have
serve a
received
copy of that. No, I am only given to you, but not to
No,
the state
but I
council.
have to get a copy from him. And another important thing I want to convey to your lordship. similar matter, similar prayer, and there is a matter pending before the Honorable Apex Court. All the states have been noticed, and I am filing the copies. That is fixed to third week of July 2022.
So that is a different thing. That is regarding
that
to
is the
agreement
same
for
thing. That is
sale.
same thing.
For agreement for sale, everyone should have a common format. This is completely different.
Lord,
Yeah.
I'm just,
The Odisha rules are not impugned before the Honorable Supreme Court.
Yes, Odisha government is also noticed in that case.
That is for an agreement for sale. Everyone, all
Odisha government
states should
is
have a
also-
common format.
That we will file the SLP copy also if your lordship directs. And
It has nothing to
so
do with the
let it-
impugned rules here.
No, from which order did it travel as an SLP? No, it's a writ petitions. These are Article 32 writ.
yes,
Yes, ma'am.
Will also
Credit
kindly
tax.
see the
All the
first
states
order.
should have a common rule for that agreement for sale.
So this is on only one aspect, sir. Absence of a uniform model built up by agreement.
Lord, your lordship is seeing the first order. Your lordship may see, then I can see the 14th of February order.
Copies of rules is correct.
Yes.
Correct.
Yes, the rules relating to agreement for sale.
No. The questions in para 3, whether there are any deviations which detract from the rights of right purchasers.
Yes.
It's all relating to agreement for sale, initial agreement for sale. That was the
Lordship
moot
may see the
question.
last line of paragraph 3. But the basic protections afforded to purchasers must be across the country in accordance with the statutory purpose of the RERA.
Salutary purpose.
Since the rules are, this agreement for sale format is not there, on that aspect, it is going on.
But there will be some overlapping.
And no, absolutely not. Because there is here the question is of association, my lord, and there it is for the agreement for sale only. I have completely verified it. It is only for agreement for sale. That over all throughout the country there should be a common format of agreement for sale because the agreement defines the rights and obligations of the parties.
My lords, if my lords would see the tenor of the order, they are looking at the larger picture across the country.
Lord, your lordship may kindly also
The
see the
Odisha
last
rules
order.
is not at all there before the Honorable Supreme Court.
Odisha was noticed.
This
And Odisha has also filed the counter affidavit.
These impugned rules are not at all there.
But this issue of what they can transfer will come in the agreement to sell, because the precondition of the association being formed, that will definitely be raised in the agreement to sell format.
First, the agreement for sale comes. That is the stage of allotment. Thereafter, association comes. So the issue, we are a step ahead here. The issue before the Honorable Supreme Court is how the format of agreement for sale, it should be common throughout the country. Only that much is the issue, my lord. I have completely verified it.
All right.
My lord, here your lordship desired on the last date, your lordship desired how these sales are undertaking. I have filed an affidavit, short affidavit, enclosing 2 sale deeds. Your lordship will be completely surprised, I must say. Your lordship may kindly see.
Copies of the same.
I have served everyone. I have served. Sir, I have served personally. On 2nd, sir, so I have served personally, sir. On 2nd of May, your lordship may just kindly see, it is there on record.
Where's the affidavit?
Yes, on 2nd of May affidavit, it is there on your lordship's board. My lord, I have enclosed 2 sale deeds. The first one is one by Trident Properties Private Limited. It starts at page 4. Now, as your lordship,
1 minute. Let's get the affidavit, please.
Yes.
What's the affidavit date?
2nd of May 2022.
1 minute. Just take it off.
18788.
No, it's not an IA, right? It's an affidavit.
No, it's an affidavit.
WPC number.
18799. My lord, in the second, my lord, that is the main petition.
Sorry.
18799.
Oh, sorry. All right. Right, affidavit.
My lord. Lordship may see page 4.
Yes.
The recital only, the first part is one State Bank of India. Then your lordship at page 5. Second is Trident Properties in favor of Santosh Kumar Mahapatra. There is no association because association as it cannot be formed. Then your lordship may come to page 12. Your lordship's query that how are the sale deeds being executed? The schedule of property which is being sold. My lord, I'll read it.
Right.
All that residential apartment bearing flat number so and so at measuring 990 square feet of super built up area, including common area and amenity. Along with car park together with undivided share of land. So the common area is being sold. So now neither they can sell it to the association. Completely they have frustrated section 17. Section 17 says along with the sale of the unit, the common area is to go to the association. Now if they have sold it to the LOT, they cannot.
How can the same common area be sold to all allottees?
It cannot be. And my lord, another more interesting thing, the second sale deed, which is one of the promoters of Credai, your lordship may, this is too much interesting. At page 26, your lordship may come.
So the government has to answer your sub-registrars.
I'll give that answer. My lord, clause 5.2 at page 26.
Yes.
The vendor shall at all times at its discretion retain the ownership of the common area of the project. That is vendors' common areas. None of the resident owners shall have any interest.
Called the vendors' common area.
My lord, from where they get this concept at all? So this is allottees' rights are being completely frustrated. Section 22.
I think nobody's reading these sale deeds carefully.
Yes.
Just mechanically getting registered.
Section 22A1C of the Orissa Amendment Registration Act says that the registering officer shall refuse to register any instrument relating to transfer of immovable property, the alienation or transfer of which is prohibited under any state or central act. So section 17 of the RERA Act prohibits the sale of common area to anyone except the association. So this, my lord, this is a very urgent situation. It cannot be allowed to continue. Right in front of your lordships, this illegality is going on.
Lord, may I just take one thing, Lord? The matter is currently pending sub judice before the Honorable Apex Court.
No. What is pending is very clear, sir. Come to the last order.
My lord.
18th April. The latest copy, what they've called for is the latest copy of the agreement for sale. And they're examining the rules in that context. So even the first order that they passed in this matter, which is on 4th October, raising grievance that in the absence of a uniform model, builder-buyer agreement and agent-buyer agreement. So they're not sale deeds. These are agreements to sell. We are at far later stage in this. say at the outset, where is your affidavit?
My lord, my affidavit I have filed.
Your opposite party number 3.
My lord, on 21/4/2022, I filed the affidavit, my lord.
Simply saying that there is no power to instruct, not to register.
He doesn't.
Where is that notification which you just now read out?
Absolutely. He doesn't even read the Registration Act. He goes to RERA Act, OAO Act, the IGR. 22A1 section C. This is
No, but he is appearing for RERA.
Yes,
Don't you say
Your
RERA
Lordship,
has no power?
Your Lordship read the IGR's affidavit, I think.
No. Opposite party number 3 is RERA.
Yes, I am appearing for RERA, my lord. I have not served my copies on the State Council as well as the Council's
It's
appearing
anyway
for the party.
one paragraph affidavit, literally.
My lord. No. This that is IGR. I am appearing for the Real Estate Regulatory Authority, my lord.
Correct.
That's a 7-page affidavit picture.
Oh, this is the IGR.
IGR's affidavit.
And he's not read his own notification.
He doesn't even know what is his. He doesn't even apply his mind.
Where is your affidavit, sir? Your opposite party number 4.
I am opposite party number 4.
Same thing with RERA. I will read one line. He doesn't even read section 17. At page 4, Your Lordship may see the first subparagraph.
Trying its best to bring those erring promoters. What is this kind of a reply, sir? You have to take a clear stand. How are these sale deeds being executed? And what are you doing to stop the execution of this kind of sale deeds?
At page 4, I may read one line. Page 4, first subpara. Subsequently, there has been a change in the recital of deed of conveyance. Now it is noticed that in almost all deeds of conveyance.
No, where are you reading?
My lord, page 4 of their affidavit. My lord, it's an affidavit. Page 4, it starts from subsequently.
Oh, one minute.
Subsequently, there has been a change in the recitals of deed of conveyance. Now it is noticed that in almost all deeds of conveyance, the promoters are alienating the proportionate interest in common area in favor of the allottees, thereby making the allottees a joint tenant in common in respect of the common area. In that case, no title remains with the promoter after execution of the sale deed to convey in favor of the association of the allottees to be. Now, what does he mean? He has never read section 17 and he's swearing an affidavit.
So this has to be in favor of an association.
My lord, I need to also examine that, my lord. What has happened is affidavit already we have given.
RERA should know more about this act than anyone else. You don't need a petitioner to point out.
May I just submit one? Now, what my learned friend for the petitioner says, there are some issues, but my lord may kindly appreciate that we are in a transitory phase where now some of these projects I know, they were prior to the RERA coming in. They started in 2010-11, ended prior to RERA coming in. And as the laws change, these builders have now become compliant. So some of these, like this sale deed he's showing of Z1, that is a project which completed prior to RERA Act coming in.
Whatever, sir. The question is this. Once an act is there, when you're registering it today, you can't be blind to the act.
No, that's there, my lord. That's why.
And RERA's established only for this.
My lord, in fact, state in there.
See, there are so many disputes that happen between apartment owners over common areas. Somebody will say, I want to use the common area for X purpose. somebody has an opposition to that. Who will control a common area? Somebody can even put up a stall in a common area. And then that becomes a problem. Saying, how can he take over? He can show the sale deed and say, the common area has been sold to me.
Promoters are now leasing the common area. Promoters are now leasing the common area. They are installing telephone towers, leasing it to malls because of this, absence of association. That's the reason why
the state has said that they are looking into all this. The state
but I'm saying what happens in sale deeds is this. Once you say you have defined something called a vendor's common area and it's in the sale deed already. The deed has been registered. It's not as if tomorrow all of us can just sit around and say, okay, this clause we will not enforce. Once you put it in a sale deed which is registered, then it has serious consequences. Then the difficult consequence is declaring some portion of the sale deed to be void. It's so complicated.
Exactly. Very difficult situation it has come due to absence of association.
Lord,
and it needs absolutely urgent interference of your lordships.
If I may, my Lord. My Lord, on the question of whether the common areas are given to the association or the individual owners proportionately.
It's not even used. The word proportionately, it's not used. Look at the sale deed. So casually drafted that part.
My Lord, actually, if I'm just getting my Lord, may kindly see. It's written proportionate, indivisible, undivided interest, my Lord. My Lord, may kindly see that has been selectively placed, my Lord. My Lord, I was asking to get a clarification of this, my Lord. I will file a clarification of this, my Lord. My Lord, may kindly see it is specifically stated that it has to be proportionate. My Lord, may kindly see page 35 of that same thing.
No, the first sale deed which
the second, if I may say, page 35.
Second, vendors common area, your lordship.
No. There was an earlier. First, you developed.
Yes, at page 12. That is
at an entire common area is being sold.
Common areas and all, everything has gone.
My Lord, may kindly see page 35. Just to because then the state might have a bigger role. My Lord, may kindly see page 35 of the same sale deed, the same affidavit.
1 minute. Yes.
My Lord, may kindly see the interest transferred is proportionate, impartible, undivided interest as enjoined in the Orissa apartment.
No. Has this to do with the common area, sir?
Yes, my Lord. Yes, my Lord. Because my Lord, may kindly see, if I may only say this, my Lord. My Lord, the common area definition under RERA also includes the land. My Lord, may kindly envisage.
No. So there is 1 minute. There are, once you have apartments,
yes, my Lord.
Everybody knows what is a common area. Just not about land. Because undivided proportionate interest in land is a known concept when there are apartments. Common areas is separate.
Yes, ma'am. Common area will be included. Common areas are the staircases, the lift areas.
Correct.
Right,
this schedule which you read,
yes, ma'am,
doesn't have to do with that common area.
Yes, my Lord. What I'm trying to say, my Lord, is if my Lord may kindly envisage it, this is a plot of land, 1 acre, my Lord. 1 acre of land.
No. This is the wording that should be used, but is not being used.
What, my Lord?
That whatever you have a common area, what can be transferred even to the association can only be a proportionate share.
No, my Lord, that is what I'm coming to, my Lord. My Lord, may kindly envisage this. Why am I saying, my Lord? Then the state has to probably look into the Stamp Act as well. May I humbly say this?
Maybe.
So, my Lord, that is why I'm saying, my Lord, state in the affidavit themselves have said.
No, what happens in the meanwhile? Just come back to that entire common area being sold to that individual apartment.
Not the entire, my Lord. Not the
at page 12, your lordship.
12. Let's see the 12.
I'll take instruction on that, my Lord. But my
no.
Lord,
Let's just read the wording, please. No. Intention is one thing, wording is another.
No.
Page 12, Schedule B.
My Lord, your lordship may read clause D. I'm sorry, page 6. That will further clarify. Page 6, clause D. The first party vendor Trident Properties offering to sell the residential apartment bearing flat number so and so on block this at measuring 990 square feet of super built up area, including common areas and amenities, along with car park, together with undivided share of land.
So when land comes, it's undivided share.
Yes, ma'am.
Common area, the entire common area is given here.
No, ma'am.
See, there is a problem in the wording.
Yes, ma'am.
And this is not like a statute. It's very different. Statute, you can have interpretations. And sale deed, people will just simply show the sale deed and said what has been sold is the entire common area.
Entire common area.
I
And the next paragraph says,
and then what happens is the question. See, this is going to give rise to numerous disputes.
It is happening.
Every vendor, every buyer here will say, look at the wording of my sale deed. All the entire common area has been sold.
My lord, I'll take instruction on those two affidavits, my lord, as they are. Because
No, whatever instructions, I'm saying you will only give an interpretation. You'll want this court to record that vis-a-vis this sale deed, Mr. So-and-so says that we should understand this to mean undivided share in a common area. What does it mean? From the person whose benefit the sale deed has been executed, why should he be bound by all this?
No, my lord, what I'm trying to say is because only sale deeds have been given here, my lord. Selected sale deeds have been given. If my lord once will clarify the issue as to how the agreement of sale deed and how the common areas are being transferred.
No.
Because my lord,
for today's hearing, I think his concern is correct. All this discussion we can have, and we can, whenever a judgment is pronounced from that day onwards, that law will apply. What happens in the meanwhile? All these numerous sale deeds that have been executed. Who's going to stop all this? Even as we speak, a similar sale deed and a similar clause is going to be registered.
Yes.
my lord, wherein, my lord, the general thing here is the common areas, all the impartible, proportionate, undivisible interest.
All this which you're saying, where is it written, sir? That's the only question that is being asked.
I showed it, my lord, page 35, my lord, may kindly have.
No, we are on page 6, read with page 12. That is another sale deed. 35 is another sale deed.
Vendors common area.
When I'm asking you about the sale deed at page 6, don't say, let us look at the sale deed at 35.
There is no uniformity, my lord.
At all.
There is no uniformity.
There's no uniformity.
So therefore, my lord, when the Supreme Court is hearing this matter, to have a uniform...
No. That Supreme Court thing is about agreements to sell, sir.
Agreement to sell.
They're not about sale deeds.
This agreement to sell, my lord.
And they're also not about formation of association. Nobody seems to have told the Supreme Court that is a basic problem. They have simply taken one small problem to the Supreme Court saying, let us have uniform agreements to sell. That itself will have a bearing, my lord. The Supreme Court has not seized off validity of sale deeds that have already been registered.
As your lordship pertinently pointed out on the last date, association should be party in the sale deed. Common area should be together with the common area should be transferred to the association.
Correct.
Otherwise, now who will pay the stamp duty now if this thing is?
My lord, may kindly see page 10. My lord, may kindly see page 10 of that same thing.
Yes.
My lord, the developer shall be. This is one of the. This is the affidavit. This is the sale deed that my lord are talking about.
We are referring to the page clause.
Page 9, clause 10.
No, I'm not able to understand. 1 minute. Page 9, clause 10. Yes, the developer shall be entitled to manage
the common areas and amenities, and when completed, as mentioned in Schedule A, till 2 years after receipt of the phase-wise completion, this. On completion of part or entire project, the developer shall hand over the same to the Trident Galaxy Owners Association, herein called the association. The vendees automatically become the member of the association to be registered under the provision of Orissa Apartment Ownership Act that may be formed by all the co-owners of the
exactly. So he should not have sold the common area.
It has been sold.
After saying all this, what you're doing, the schedule is selling it.
Common area has been sold. It cannot be sold off again. It cannot be handed over.
Once you say this, you should have excluded from Schedule B the common area altogether.
Promoter doesn't have any right title to again hand over.
My lord, then my humble submission is the state government.
He should have simply said, instead of including common area, he should have said excluding common area. The word including should have been substituted by excluding, because this has to be read with what you just now read out, saying that as and when the association is formed, it will go transfer to the association.
My lord, as I said, my lord, the state government, I know what you've fallen from, lordship, what happens in the meantime.
Our concern is that we can't have sale deeds like this getting registered on a daily basis. It's a fait accompli. People will say, no, whenever the High Court declares the law or Supreme Court declares the law, from that day we will adopt the correct wording of the sale deed. Till then, whatever has happened has happened.
My lord, in fact, if my lords may bear with me, I know it's very confusing here. My lords may just see. In fact, this document we got yesterday night by him.
I have served.
Whenever, sir.
My lords may
it is their document. Their sale deed.
Probably it will throw some light. My lords, clause 6, page 4 of that sale deed. page 4, clause 6. The vendee agrees.
1 minute.
The vendee agrees that the undivided share of land purchased by him, her, them will not entitle to any exclusive rights in respect of any specified area in the Schedule B property.
Right.
And that she will not claim any exclusive rights. So Schedule B is what was shown to your lordship.
No, all this is again interpretation. See, I'm just saying this is all unnecessary.
My lord,
we are having to bend backwards to somehow rescue the sale deed.
Yes.
The simple concept, as he's trying to point out, is common areas go to the association. No association is formed. You can't, till the association is formed, you can't transfer the common area.
My lord.
It's simple. I think the sequence is quite simple. We're unnecessarily complicating it.
This
in a hurry to register sale deeds, because when buyers can't wait indefinitely, they've parted with money. But you have to find a solution then.
In fact, they are probably the counsel for the PIL petitioner is trying to paint us as the
not you.
Bad men,
no.
We want
he's worried about registering authorities. He's very worried that registering authorities who are supposed to guide the apartment buyers properly.
We will
RERA is supposed to guide them. The registering authority is supposed to guide them. Nobody's guiding them.
Unless the association comes, this cannot be solved, my lord.
No, my lord, may I suggest something? My lord, I was sitting here. I didn't know about this case. My lord, I would submit, subject to your lordship's kind consideration, that RERA and the state government will sit and lay down some guidelines.
No, also you have to reconcile the rules. What is happening is we have two sets of rules.
Lordship is right.
One at cross purposes with the other.
Correct.
One is not allowing the association to be formed.
No, my lord, I will look into it.
That rule has to go so that associations can be formed.
My lord.
See, once somebody books a flat,
my lord,
from that day onwards, he will also be part of an association.
Well, actually, in Delhi and other places, there is a cooperative society system.
That's right.
Where the cooperative society builds, they get the land and they either build it themselves, and whoever gets in, suppose one member exits, another member enters.
No, but there also now,
yes,
with the RERA Act having come in,
lordship pleases,
that takes over. See, once the RERA Act holds the field,
my lord,
there have to be corresponding amendments to the older rules and all of that.
Correct.
Say only the RERA legislation will govern.
So, my lord, what I would submit for your lordship's kind consideration is RERA and the state government will sit down and lay some guidelines which will go to the registering authority. So while they are registering, they will check whether they are compliant or not.
Yeah, that's right.
That's one way of looking at it.
Till then, do we just allow these registrations to go on?
It can happen in the next 7 days, because we don't know, so many people are registering.
That's right, all over Orissa.
And not there, the problem will be then their registration will be stopped. So we will try
in abeyance for some time. Otherwise, what will happen is
the guidelines will not can be made in the next 7 days. So 7 days, whatever we are in the lordship's hands, because
even if they make the guidelines, unless they form an association, they make the rules. The common area cannot be transferred. The guidelines won't help, my lord. I don't know why they are reluctant to bring this concept of association here. They do not simply want to establish the association. That is the moot point.
No, except in one of them, he actually names the association. Trident Galaxy.
He's giving a hypothetical name.
What is hypothetical? Whatever you say is correct, and what the rest of people say is hypothetical. I don't understand.
These two projects, Trident and Z, these are all projects which started in 2011. RERA comes in 2016. So, and these are all multi-phase projects. It's not one building over. So probably construction will continue up to 2030. That's the reason why this confusion is coming up, as it fell from the learned AG.
But we have to find a solution to the problem.
We are willing to cooperate. Now, my learned friend for the petitioner, in my case, in Trident, he has taken us to the loci, to the consumer courts, to RERA, to this court. The directors are facing anticipatory bail, and there also he is objecting anticipatory bail. If this is the manner in which promoters are hauled up, then it would not help any of the individual owners.
Why? Because the sale deed which I showed, there is no occupancy certificate.
Just 1 minute.
Still sale deeds are being registered.
Let me submit, my lords.
No
the
occupancy
association
certificate
cannot block individual rights in this manner. We are willing to cooperate with the government and all the stakeholders and arrive at a solution. But we are being hauled up in criminal courts.
No, see, we are, as far as the present petition is concerned, like I told you, the issue is quite straightforward. You have two sets of rules which are contrary to each other.
Yes.
If RERA has to hold the field, let's go by the RERA.
RERA has to hold the field.
Correct. So the other rule has to go. Associations have to be formed. One association is formed, common areas gets transferred to the association. As simple as that. I don't know why we should complicate it beyond that.
Exactly.
Whatever is happening in with your individual builders, other cases, we are not going to comment on it. We're not even concerned with that.
Exactly.
In fact, what fell from your lordships, we can build on this and have one format of a sale deed.
Exactly.
Which will be followed
That
by
is what
everyone.
he's been asking, and RERA should do it.
So that's what
RERA should come forward to say this is the format of the sale deed.
My lords, once the learned AG has said, my lords, we can always go back to the drawing board and come back to your lordships. But if now there is a stay order on registrations, then individual buyers will be affected. Now he cannot claim to be the custodian of all individuals, small buyers, small.
Flats. Can we not ask the registering authority hereafter to adhere to this notification dated 22nd February 2014 and ensure that no provision of the RERA Act is violated?
Section 17 is not violated.
See, we don't even have to tell him that some act should not be violated, but it's just because he's filed an affidavit saying, I don't know how to do it. You have to educate him.
I completely bow down to your lordship. My lord, may I just submit one thing? Since the learned AG wants 7 days, my lord may call it on.
No, that will go into vacation.
No, it will go into vacation. My lord, may I suggest this, my lord? May I suggest this? That the RERA and state government in the next 7 days will lay down the guidelines.
No, we'll only say that hereafter,
yes, madam,
all registrations will abide by this notification dated 22nd February 2014.
Yes.
As well as the RERA Act. As simple as that. Yes. Then they will be forced to read the Act. They will ask the question, where is the association when you want to transfer common areas?
In fact,
let them do that.
I was just coming out of a case before the single bench and the division bench in another 2 coordinate courts, where the association went completely against the individual owners. And in fact,
all this is bound to happen.
One of these associations are involved.
Mr. Mishra, I can 100% guarantee that these clauses that we just read in these sale deeds are going to give rise to numerous litigations.
Exactly.
And all avoidable. So, completely avoidable litigation is going to come up now.
My lords, as it fell from the learned AG, we'll go back to the drawing board and have one format.
No, I don't know. You'll probably give them proper legal advice to what to do with all these sale deeds.
We would. In fact, in the first matter, most of the complaints of Mohit have been addressed. Sale deeds have already been executed.
They are going into the merits. We have a different point. They are beating around the bush every time.
No.
First, the association has to come, my lord.
So, once I came in, my lords, majority of these individual concerns have already been dealt with. We are not here against our own customers.
In the meantime, the impugned rules have to go. That is completely contrary to RERA Act, as the learned AG also accepted.
Now, staying for the registration.
With my lord's kind permission, my lord.
Yes.
With my lord's kind permission.
Yes, Mr. Paul.
My lord, I am appearing for the. Yes, my lord. My lord, I am appearing for respondent number 4, my lord. I have given it some thought, Lord, on this matter. My lord, one is the Apartment Ownership Act, which was modeled along the Maharashtra Apartment Ownership Act, where, as my lord say, the common areas and the right undivided interest in the land goes to that association once the sales of all the flats takes place. Now we have today another situation under RERA, where a association has to be formed at the very inception. Now that is the interpretation given by the petitioner. At the very inception.
not by the petitioner. You see, the plain reading of the RERA provision envisages, because of this experience that we've had, that many people who book for apartments are getting the rough end of the stick. I mean, they're suddenly finding themselves in the lurch, having parted with money, no apartment coming up. So the association being formed has now become the starting point, not the point of, after I become an apartment owner, I'll then become a member of association. So the legislative scheme today seems to be, let us protect the rights of consumers right in the beginning.
Yes.
And give them a collective right of taking on. You see, the builders are powerful in the sense of resources they have. And individual apartment owners don't have those resources.
I quite follow what my lords are saying, my lord. May I just take this liberty, my lord, in this matter? My lord, even the Supreme Court is seized of this matter. And
that we saw those orders very carefully. The Supreme Court is seized of one small aspect of the matter, which is the agreement to sell format.
Please, my lord.
In Orissa, what has happened is we've gone far beyond that stage. Today, we are having on a daily basis sale deeds being registered. So we are beyond the stage of agreement to sell.
I saw the two sale deeds. My lord, there is an explanation. We'll just put in an affidavit to that effect, my lord. In a day or two, I will not take more than a day.
No. The difficulty, Mr. Paul, is this.
Yes.
You as opposite party number 4, I mean, who's this? Opposite party number 4 is RERA.
No. The Builders Association.
Even if you offer an explanation for somebody else's sale deed, that is not going to help.
No,
it's not a statute. It's not a statute. Somebody who's the beneficiary under that sale deed is going to say, listen, the entire common area has been sold to me. I don't recognize any association. They'll say the association is to buy it from me. You never know. People come up with all kinds of strange arguments.
No, my lord, I am only here to assist and nothing more. And
no. I understand. I'm saying it's a pure legal question which we have all to address.
Please, my lord. And there has to be a reconciliation of the Maharashtra, the Apartment Ownership Act.
Exactly.
And now that is also another.
Actually, I don't know if you've read the first very order that we've passed in the matter. We've highlighted this very issue.
Yes, my lord. The first order.
The very first order in 18799.
Yes.
7th July 2021.
The orders.
See, that is the issue highlighted in the very first order, 7 July. That how to reconcile these two things, the Orissa Apartment Owners Rules of 2021, amendment rules, and the RERA provisions.
For instance, my lord, in Bombay, in Maharashtra for that, there is in the rules itself exactly what the sale deed will recite.
Yeah, unfortunately, Orissa doesn't have that. See, and after the RERA regime came in, they've not re-looked at it. That's the issue.
Because if we have the rules itself providing that this will be the recitals in the what was under the Maharashtra Apartment Ownership was called the deed of apartment. This will be the deed of apartment and nothing more, nothing less.
In Orissa, there is nothing like that, sir. The problem is in Orissa, we don't have anything like that. And that is what he's been asking for. In fact, even the builders want it. See, everybody will be helped if there is clarity on this. Right?
Absolutely. Absolutely. Absolutely.
Right. You see in 18799. So I'll take on board your suggestion.
Please.
Yeah.
I before your lordships, my lord, wind up this matter. I just want to
wind up. There's no question of winding.
Wind up. But today, my lord, lordship, may kindly see, my lord, we have an agreement for sale. The Orissa has come up with an agreement to sell, my lord. That is an rule as per Rule 8.1 of the RERA Act, my lord. I'm giving the copy of this, my lord. Also, may kindly come to clock G.
Yes.
Clause G may says, Lord, the allottee had applied for an apartment in the project-wide application number so-and-so dated so-and-so, as has been allotted apartment number so-and-so having carpet areas of square feet type on the floor, building along with a garage, closed parking number so-and-so at measuring so-and-so square feet. Please insert the location of the garage, closed parking as permissible under the applicable law and pro rata share.
So that's the problem, sir. Act says it can be only transferred to association. So this also is wrong then.
My lord, can I only beseech your lordship to come to section 17? Oh, just for the discussion that we are having, my lord, just for the.
What I am praying, my lord, if the Supreme Court has now, my lord, they have seized of this matter relating to agreement to sell.
No, there you can always point out to the Supreme Court that our rule is wrong. Please go and tell them that we are going to frame a proper rule. Nobody prevents you
So
from.
once that rule, my lord, is in
sale deeds here.
My lord,
Lord, may grant us, my lord, what has fallen from Lord Advocate General, my lord. We will have a meeting.
Why we are
7 days
my
time.
lord, I may sound slightly discordant here, my lords. Why we are apprehensive, I'll tell your lordships. These are all projects where agreements to sale were executed in the year 2013-14 prior to RERA.
Correct.
Now, all those sale deeds are now coming in.
Yes.
So if suddenly there is a direction that you comply with RERA.
No, because RERA is now holding the field.
Correct, my lords. The problem would be then we will have to go back on what we had promised in the earlier agreements to sale.
This is a statutory intervention.
Yes.
So and everybody has to follow the law.
Correct,
so nobody is going to haul you over the coals saying, no, in the agreement to sell you said this and now you're saying something else.
All that, my lords, we are saying is let there be a clear cut-off date so that we are fully compliant.
The Act itself is the cut-off date, please. The Act was the cut-off date.
Now, unless, my lords, unless there's a specific format, at this stage, the problems would
Doesn't mean in the absence of a format, you will simply say, I'll ignore the RERA Act and go ahead and do whatever I feel. You cannot. See, you are actually, Mr. Mishra, I'm surprised. The builders should themselves say, we don't want to invite more litigation in the future.
My lords.
Whereas now you're saying, no, we'll talk about the litigation whenever it comes. Today, let us go ahead and register sale deeds.
No, it's not that.
Yes. You're not anticipating what trouble you're going to be in. You're going to be in serious trouble tomorrow when somebody turns around and shows you the act and said, how did you register a sale deed violation of this act?
My lords, I can only submit, my lords, so far as my case is concerned.
See, when things go wrong, everything will be pointed out.
My lords. Now, so far as the first case is concerned, I was trying to submit earlier, my lords. Here, the promoters have been hauled up before each and every forum.
So we are not, let me repeatedly tell you, you may have numerous problems.
My lords.
We are not here to address all those individual problems that builders have.
My lords.
We're addressing a very, very small issue in terms of what the issue is.
My lords.
There are the Orissa apartment owners rules, which is sitting contrary to the RERA section 17 clauses. Those have to be reconciled. Without there being a formation of an association, you cannot have common areas transferred to anyone, including what he's trying to point out, pro rata share in that common area to individual apartment owners. So how do you solve this problem? This is the only issue we are dealing with, nothing more.
My lords, if my lords would allow, what fell from the learned AG, all that he requests for is 7 days. We will go back to the drawing board and come back with some concrete.
No, we are not preventing you. Let's be clear. This is not the final hearing. This is not the last day this matter is going to be heard.
My lords.
Till the solution is found, this matter will go on. So let's there be no, I'm making it clear to everyone, we're not ending this matter here today.
My lord, because my lord, the interpretation of section 17 might also have to be done, my lord. That's so.
Which is what the whole petition is about, sir.
My lord, that's what I'm saying.
You see, write down in 18799, on the very first date of the hearing of this petition, on 7 July 2021, the court had noted the central issue, which is the inconsistency between the Orissa apartment ownership amendment rules 2021 and section 11 (4) (E, F) and section 17 of the Real Estate Regulation Development Act 2016 RERA Act. In a subsequent order dated 5th April 2022, the court had noted how the Orissa Real Estate Regulatory Authority (ORERA) had written to the Inspector General of Registration (IGR) on 14th May 2019 drawing attention to section 17 bracket 1 of the RERA Act, and specifically stating that requests for registration of conveyance deeds in respect of real estate projects should be rejected if the ownership of the common areas is not conveyed to the association of allottees as is required under the said provision. Full stop. This court then asked Orissa to make clear its stand on the main prayer in the petition, which was for declaring the Orissa Apartment Ownership Bracket Amendment Bracket Rules 2021, which mandates that an association of apartment owners will be formed only after execution of the conveyance deeds in an apartment, on the ground that, open quotation, it is repugnant to section 11 bracket 4 bracket small e, section 11 bracket 4 bracket small f, and section 17 of the RERA Act, unquote. Paragraph. Pursuant to all of the above orders, a series of affidavits have been filed, which the court will refer to hereafter. Full stop. RERA has filed an affidavit Orissa has filed an affidavit on 21st April 2022 claiming that the Orissa Apartment Ownership Bracket Amendment Bracket Rules 2021, open quotation, binds the promoter as well as allottees, and there is no ambiguity to that extent between the RERA Act and the Orissa Apartment Ownership Bracket Amendment Rules 2021, since the proviso to section 11 bracket 4 bracket f deals with enactment of local laws and that the local laws shall prevail. Full stop. The said amendment misses the point that the central challenge in the petition itself is to the exception carved out for local laws, as that would completely defeat the purpose of section 17 read with section 11 bracket 4 bracket e and bracket f of the RERA Act. Full stop. In addition, Mr. B.P. Tripathi, appearing for Orissa, has drawn attention of the court to annexure to the format of the agreement for sale, which is part of the Orissa Real Estate Bracket Regulation and Development Bracket Rules 2017 bracket Orissa Rules bracket, in which format there is a clause clause G, which talks of individual apartment owners being conveyed, open quotation, pro rata share in the common areas as defined under section 2 bracket N of the RERA Act. Full stop. Such a clause, in fact, is contrary to section 11 bracket 4 bracket small e. No, 1e is or 4e? 4 bracket e. No? Yeah, 4 bracket e, my lord, of the RERA Act.
My lord.
Read with section 17. Bracket 1 thereof. Paragraph. At this stage, it must be noticed that counsel for the state as well as counsel for the RERA and counsel appearing for the public builders associations have referred to the orders passed by the Supreme Court of India in writ petition civil 1216 of 2020 bracket Ashwini Kumar Upadhyaya versus Union of India bracket and batch.
My lord, my apologies, my lord, I'm called in the other.
Yes, please.
Lordship, please.
Yeah. This court has perused the orders dated 4th October 2021, 14th February 2022, and 18th April 2022 passed by the Supreme Court in the said writ petitions. It is plain from those orders that the Supreme Court is seized of one particular issue regarding open quotation absence of a uniform or model builder buyer agreement, an agent buyer agreement, unquote, under the RERA Act. Full stop. However, in the press, full stop, it was accordingly urged, this court is not inclined to accept the submission of the counsel for the opposite parties, that this court should await the outcome of the said writ petitions before proceeding to hear these petitions. Full stop. The issue here is regarding actual registration of the sale deeds themselves, and whether such registration of sale deeds come up where common areas are being conveyed, where the share in common areas is being conveyed to individual apartment owners, inconsistent with the requirement of the RERA Act, can be countenanced, can be legally sustained, question mark. That issue is certainly not seized off by the Supreme Court in the said batch of writ petitions. Paragraph. An affidavit has been filed by the opposite party number 3, namely the IGR, stating that there is no provision in the RERA Act or even in the Apartment Ownership Act 2019 for IGR. The notification dated 22nd February 2014 of the Law Department amending the Orissa registration, amending the Registration Act of 1908 by way of the registration bracket Odisha Amendment bracket Act 2013, which has inserted section 22 capital A in the Registration Act 2008, which reads as under. The whole thing, refusal to register documents, and then A to A. It is therefore plain that the registering authority is bound to refuse to register an instrument of transfer of immovable property open quotation, which is prohibited, immovable property, open quotation, the alienation or transfer of which is prohibited under any state or central act, unquote. With the RERA Act mandating that the transfer of common areas should only be in favor of the Association of Apartment Owners, deeds presented for registration, sale deeds presented for registration, which contain clauses contrary thereto, cannot be allowed to be registered by the IGR. Full stop. It should not be difficult, therefore, for the IGR to issue instructions in that regard in terms of section 22 capital A of the Registration Act 1908 to all the sub-registrars. Paragraph. Now to turn to the affidavit filed by the petitioner on 4th May 2022, enclosing copies of certain sample copies of certain sale deeds executed by two of the builders, that is Messrs. Trident Properties Private Limited and Z Estates Private Limited. Full stop. These sample sale deeds, which are at annexures 13 and 14 to the said affidavit, reflect the confusion which has led to the filing of the present petition. Full stop. They proceed on the basis that while the sale deeds might acknowledge that there is a need to form, that is the need for an association of apartment owners to be formed, they proceed to convey the common areas to the individual apartment owners and not to the association of apartment owners. Full stop. It is a matter of concern that these type of sale deeds are getting registered on a daily basis, and such registration may be contrary to the RERA Act and the rules made thereunder. Paragraph. The Learned Advocate General for Odisha was present during the hearings, has made a statement that the state government and the ORERA will sit together in the next 1 week to work out a solution to the problem. Full stop. He has assured the court that the proceedings of such deliberations will be placed before the court with an affidavit before the next date of hearing. Paragraph. While the court is confident that a solution can be found by the authorities by reconciling the two contrary statutory enactments, namely the Orissa Apartment Owners Amendment Rules 2021 and the RERA Act and the rules thereunder, the court would like to direct, the court directs that in the meanwhile, the IGR will strictly enforce Section 22 capital A of the Registration Act 1908, inserted by the Registration Odisha Amendment Act 2013, and ensure that sale deeds registered hereafter strictly abide by the provisions of the RERA Act and the rules thereunder. You say, for considering the further arguments of parties and awaiting the outcome of the deliberations between the state government and the ORERA. List on. So we'll have it on the opening itself.
Yes, Your Lordship.
Huh?
Yes.
23rd June.
Sorry, yes.
Just make 23rd June so that we don't get any major battles. Mr. Paul will also be there on 23rd June. You may have to you're not audible. You're not. Mr. Paul, you're not audible.
Supplementary list for admission item number 15.
May please. Your Honor, in the matter may be passed over. Mr. Chimanka is now by court.
All right.
14 and 15.
All right. Are the pleadings complete here or
15 and 16?
Your Lordships have already framed the question of law rather.
Yes, in my matter, item 15.
16.
Item
16.
Oh, 16. Pass over.
More of 15.
I have filed two IS bills. One for delay bills. Delay is for 2 days.
All right. The delays condoned. 18 of 2020, delays condoned. All right.
And questions have not been framed in this case. If your lordship admit the matter and my friend can take notice, the matter can taken up any day.
All right. In 16, you say the delays condoned. Then you say notice. He accepts notice. Just on 21st July.
IA may be another IA for stay may be taken on record because that has not come today.
It's not come on. That is what? 17.
IA 17, my lord.
So you put down both IA 17 and this ITA. Notice. Right.
17th minute.
July?
21st July.
21st July.
21st July.
15 is passed over minutes.
Yeah, 15 is passed.
Much obliged.
All right.
Supplementary list for hearing item number 17.
Please, your lords. Lords, here I am told that a notice was issued to the appellants because the appellants did not appear when the matter was listed.
Correct.
Lords, appellant number 1 is on video, my lords. Appellant number 2 is ill and is therefore he is not in a position to appear.
What about appellant number 1? Sorry?
One is on, he's on video link. Actually.
Oh, he is on video link.
My lord. Go on.
Where is that? I don't see him.
My lords, I think he got disconnected. I'm just asking.
All right. Anyway, yes. So we can proceed, sir.
Can I pray it may be taken up after vacation because I'm not ready in the matter. The paper books were supplied to a counsel engaged by legal aid.
No, only difficulty is a 22-year-old matter.
I know that, my lords.
Mr. Panda, actually what's happening is Supreme Court is monitoring all of this.
My lords, your lordship may take it up immediately on reopening. I'll get ready in the meantime. My lords, the appellant 1 is there.
All right. You say appellant number 1 is present in video link. And appellant number 2 is?
He's hospitalized.
Is said to be hospitalized. You say Mr. Panda, appearing on behalf of the appellants, states that he's not ready with the arguments today and prays for a short adjournment. We'll have it on the opening day then.
Yes.
List on 20.
Day after opening. Not on the opening day, the day after it opens.
All right, 21st. 21st June. All right.
Supplementary item 18.
Well, this matter, I am sorry to mention, my lord, this matter was before your lordship. Since the appellants are not there, my lord, I have prayed for a time, my lord, and one of my associates, my lord, who died during the last corona, my lord. Your lordship was pleased to adjourn one matter on 21st, and this matter, my lord, after vacation, in presence of Mr. Kotikia. But this matter is listed today, my lord. On 19th, this matter was listed on my lord.
Where is Mr.
Your lordship was pleased to adjourn this matter to 19th. One matter to 19th, my lord, and this matter to after vacation.
No, are these connected matters?
No. I still remember your lordship said that a date fixed, your lordship said fresh after summer vacation. I said
No,
yes.
not all matters like that, sir. Is this if this connected? If it is a connected matter, I can understand. If it is not connected, it is anyway a 20-year-old matter, sir.
Yes, miss. I am conscious, my lord. I mean that your lordship may fix after vacation, my lord.
Why should it get adjourned, sir? Every matter, what is happening is any 20-year-old appeal, you are simply unable to proceed with the appeal.
Well, that is why my briefing counsel, my lord.
I wish people watch these proceedings. People blame the courts all the time.
No, my lord, no question.
All the time courts are told you are delaying matters. I wish they watch these proceedings to know we are ready to go on. We are ready to go on with every appeal, sir. Every old criminal appeal, the lawyers keep asking for adjournments.
I am obliged, man, will cooperate with your lordship. Any date after vacation, any date. We will cooperate with your lordship. So old appeals, your lordship will cooperate.
No. What is that meaning? I don't know. There's no meaning left. Then if cooperation means every hearing, I will ask for an adjournment.
No, man, this matter, my lord, specifically, your lordship had directed matter to be listed after vacation, but it has come.
No. Sir, unless they are connected matters, they can't be adjourned.
No connected matter. Because the briefing counsel died, my lord, and I didn't have brief. Therefore, taking into account my difficulties, my lord, lordship was kind enough to adjourn. And Mr. Kotika, the state counsel, was present also. I will not tell him. Any date, my lord, lordship may fix after vacation.
At the request of Mr. Nayak, learned counsel, senior counsel appearing for the appellants. Opening day, sir, 20th June.
22nd and 23rd. Just opening day, my lord, not. Second or third day, any day.
21st, sir. Either 20th or 21st. You make a choice.
21st.
All right, 21st.
And my lord, I have
It's made clear that no further requests for adjournments will be entertained.
As you lordship.
Supplementary item 19.
19, my lord. May please, your lords. My lord, the appellant in this criminal appeal challenges the imprisonment for life and pay fine of rupees 5,000 in default to undergo the rigorous imprisonment of 6 months in the session trial number 113 of 2009. My lord, the fact of the case is that then on deceased Dolly Singh is the page 4 of the paperwork.
Yes.
The deceased Dolly Singh is the wife of one Ledga Singh PW2. Accused Kandra Singh is a co-villager of Ledga Singh. Bandhu Singh PW3 was the ward member of the village at the relevant time of occurrence. Who is the informant of this case? The murder of the deceased is alleged to have been committed in the night of the 6/12/1998. Day before the occurrence night, the deceased husband Ledga Singh got his wages, and in the evening, he along with his deceased wife, mother-in-law Taramani Singh PW1 had gone to Raksi weekly market for marketing, which is a distance of about 1 kilometer from their village Purana Pani. The deceased and her mother returned back to the house, whereas the deceased's husband, Ledga Singh, stayed back near a bridge, and later he returned home at 8 p.m. He found his wife not present in the house, and he was informed that the deceased had not returned to the house. On the next day morning, Ledga Singh's daughter, Sabitri, found the dead body of the deceased lying on the backside house of the Raghu Singh. Having noticed the dead body of the deceased lying there, she immediately came and informed Ledga Singh, and on receipt of such information, Ledga Singh rushed to the place and saw the dead body of the deceased with bleeding injury on her head and chest. Thereafter, Ledga Singh came to the ward member of the village PW3 and narrated the entire incident before him, who in his turn proceeded the K. Balanga police station and orally reported about the occurrence before the OIC Balanga police station, who reduced the same into the writing and treated the same as FIR, which is marked as Exhibit 1. After the registration of the case, the OIC undertook the investigation of the case, in course of which they examined the informant and other witness, visited the spot, which is the backside house of the Raghu Singh, held inquest on the dead body of the deceased as per inquest report Exhibit 2. Blood-stained earth and sample earth were seized from the spot, along with broken bangle of the deceased. Sent the dead body of the deceased to the Lahnipara CSC for postmortem examination under the dead body challan number, under the dead body challan, and on 9/12/98, the IO seized the wearing apparel of the deceased. The IO could not apprehend the accused on 11/12/98, and thereafter his arrest, his wearing apparel were seized on 12/12/1998. The accused was sent for medical examination, after which he was forwarded to the court. My lord, the plea of the defense is completely denied, and the prosecution to establish his case examined as many as 15 witnesses. Man. This case, the FIR was lodged against an unknown person, and this case was based on a circumstantial evidence. There is no eyewitness, and on last seen theory. Only the evidence of PW8, my lord, which is, may I read, my lord, the deposition of the PW8, my lord?
Yes, PW8.
PW8, my lord, page 50. I know the accused standing in the dock, who is my Mammu. Deceased Dolly Singh was my aunt, mine being the wife of my Mammu, Ledga Singh. Dolly died about 4 years back. The incident took place a weekly market date. On that date, I was sitting nearby the fire. Dolly came there and sat with me. After some time, the accused came to the place.
1 minute. The name of the accused is what?
Kandra Singh.
Kantra Singh.
Again.
So Kantra Singh is also his Mamu.
My lord.
And Legda Singh is also his Mamu.
Mamu.
Are they what? How are they
Only
related?
Village related.
Village related.
Co-villager.
Co-villages are also called Mamus. I see. All right.
My lord. After some time, the accused came to that place and called Dolly, the deceased, to accompany him to drink handia. Thereafter, both
1 minute, please. They are known to each other then. The accused and the deceased are known to each other.
Then I proceeded to my. I sat there for some time and I proceeded to my house and slept. I was sitting in front of my own house after lighting a bonfire. At that time, my parents, my sister were with us. Later on, while I was sleeping in my use, accused came and asked me to accompany him to Jatra. I went to the Jatra in the company of the said accused. As it became Jatra, instead of coming back to my house, I spent night in the house of Kandra Singh. At that time, his wife was also there, but she slept in a different place, and myself and accused slept in one place. That night, accused Kandra Singh confessed before that he took Dolly along with him for sharing handia and then committed rape on her near a mango tree standing by the side of house of Ledga Singh, and then committed her murder by pressing her neck, as Dolly stated that she would be killed by her husband if he knows about the rape. The accused also confessed that he committed the murder by pressing her neck. He further confessed he dragged the dead body and threw in the nearby field. He also stated that I should not reveal this fact to anybody. I was examined by the police. My signature was also that was my name in cross-examination. To my knowledge, my mother is the only daughter of my maternal grandfather. Ledga Singh is the only mom. I was examined by the police on the day the dead body was discovered. I was examined by the police on the date the dead body was discovered. My dead body was discovered the next day of the occurrence. That is 7/12/1998. So I was called to by the PS by the police officer. By the time my arrival at the PS, it was already night. The witness again say I arrived at the PS at 8 a.m. By 12 noon, I returned from the PS. Chowkidar came to call me. Chowkidar was guarding me all then while I was in the police station. It is not a fact that the police told me that unless I give statement as per his saying, I shall also be entangled in this case. The accused is my neighbor. The distance of our house will be 60 meters. No other house stands nearby my house. Myself, my parents, and my mother and my wife reside in our house. I have not revealed the fact of confession made by the accused before me to anybody else. The witness again say, I have told about these things to my parents and villager, but FIR is against unknown person. These things to court. On the next morning, I revealed this fact of confession to my parents and other villagers. I never shared a feast with the accused. I never visited any yatra with this accused on earlier occasion. I have not shared country liquor with this accused. I have never gone to attend any marriage ceremony with him. He is not my agent. Accused is my mamu by village courtesy. It is a suggestion.
Can I clarify, my lord, one thing?
Yes.
PW8 and 10 are related. PW10 is the wife of one Raghu Singh and PW8 is her son. So, and the accused is the younger brother of PW10, the lady, Rupam Singh. So that is how they are all related and known to each other.
Okay. Yes, so what is your comment?
No, man, there is no motive, my lord. There is no medical evidence against rape. Only FIR is against an unknown person. Only this extrajudicial confession of.
What are you saying only? What more do you need? This is a solid evidence.
No, man. Yes,
There's no cross-examination of this person at all.
And extrajudicial confession of PW8 is corroborated by PW10. Both of them speak the same thing.
If my lord, he has informed the name of the applicant will be reflected in the FIR, my lord. But he need cross-examination. He said, I was examined on the next day of the occurrence. So he have disclosed on that day. In his cross-examination, he said that I was examined by the police on the day the dead body was discovered. So the dead body was discovered on 7/12/1998, day following the occurrence. FIR was lodged against an unknown person. If we know the confessed before this PW8, he must have.
He's also recorded as 164.
164, yes. 164.
164 was recorded.
So he has stood by his statement, sir. 164 was recorded when? 18 January. 1 month later.
1 month later.
Age is all going all right. In 1979, sorry, 1999. When was this recorded? 18 January 1999.
1999.
So he's 21 years, and then when he's deposing, it's 2003, it becomes 22. That's okay.
Two 2003.
He's been on bail since 2011. He's been on bail. Anything else, sir?
No, my lord.
All right. The appeal is dismissed. We'll give you the detailed order. The bail bonds are cancelled.
Item number 20.
Please. This matter has been assigned to me on 4th April by State Legal Aid Service.
Right.
I need some time to acquainted with the facts.
What is your name, sir?
Divyasri Rai, my lord.
Mr. Rai, learned counsel appearing for the appellant. Have you got in touch with the appellant?
Yes, my lord.
Have you got in touch with the
No,
appellant?
I have not got in touch. I will try.
Please do that, sir.
I will try.
Kindly do that. Who's on the panel of the legal Orissa High Court Legal Services Committee states that he has been interested.
Yes, but SR of notice regarding personal appearance not received by us.
You see, there is no report of service of notice on the appellant yet, and then you put down fresh notice be issued to the appellant through the concerned IIC to ensure his presence in the court on the next day. You also get in touch with him, sir.
I will try.
Just on 28th June.
After vacation.
28th.
Okay. Supplementary item 21.
May I please, Your Lordship. And in this case, I am received this brief on 27th April. My lord.
All right. Are you ready with the matter? Then you carry on.
My lord?
If you're ready with the matter, please carry on.
I am not ready, but I prepare a note of argument.
You prepared a note of argument.
Yes, my lord.
Show us.
Let it come after vacation. I will.
Oh, I see. All right. Everybody seeks only adjournments. What's your name? What is your name, madam?
Tapaswini Sinha.
Miss Tapaswini Sinha. The counsel appearing on behalf of the Orissa High Court Legal Services Committee states that she needs some more time to prepare the arguments. What about service of notice in the appellant? So again, same thing. The service report of notice on the appellant has not been returned. Fresh notice to the appellant through the concerned IIC to ensure his presence in the court on the next date. The list on the same 28th June.
Yes, ma'am.
Supplementary list item number 22.
May I please, Your Lordship? Yeah, I received the brief last week, Your Lordship. No.
Same, one more adjournment. So same order, same date.
I could not contact the appellant because no contact number is there.
Again, no report of service. Same order. 28th June. All right.
Supplementary item 23.
What is your name? Is Manasi Das? All right. Then put down only her name, Miss Manasi Das. 23.
Item 23.
My lord, there's a report of the IAC Joda PS, my lord. Flag D, my lord.
I may be pardoned, Lordship. I am the previous counsel, Lordship. Since my name was not appeared in full, that was I could not make myself appear before the last date. But earlier I had communicated to the accused, and he has come today, Lordship.
Where is he?
Present.
The appellant is present. Where is he? He's the appellant.
He is the appellant.
How old is he?
He's 30.
He was 19 years in 2004.
2004, 19 years. Lordship.
He's maybe 37 now.
Doesn't look like.
Yes, Lordship. That.
He's got some ID card or something?
He has the jailer ID card, but he has the voter card that is wrong.
That is wrong.
That is his name is wrong. I found that his name is wrong. His Boishak name is Boishak and voter card is Boikuntha. But jailer ID card is there.
Are you sure he's the person?
Yes, yes. He holding the jailer jail passbook. He's keeping outside the document. He kept the outside document just here.
Doesn't look like a 37-year-old man.
Oh.
No, he has at the time of granting bail, he has once contacted me. He was 9 years in custody. After 9 years, he was gone.
All right. So proceed with the matter, sir. Proceed.
But the last order, Lordship, can
ask him to sit behind.
The last order, Lordship, already directed to engage in new counsel.
That's all right. Since you're there, it's okay. What about the legal aid counsel who was engaged? No, they are not here today.
No, madam.
How is that possible? The legal aid counsel should also be present. This is item 24.
Order dated 7/4/2023.
What is your name, sir?
My name is Rudra Narayan Parija. But
R.N. Parija.
Yes, cause list it is coming in short name. That is why I missed the list.
Anyway, so Rupesh Kanungo must be the legal aid counsel. All right. All right, carry on, sir.
Let's see here. Paragraph 7 is the relevant portion of the judgment. Let's see, I may be permitted to read the paragraph 7 of the judgment.
One minute.
The PW2 is the witness on the basis of which the entire conviction was made. Let's see.
Just read the first paragraph. Case of the prosecution. Second paragraph.
Yes, Lordship. The case of prosecution is in brief is as follows: that the incident occurred on 13/6/2003, and that the mother of the accused left the house by quarreling with his father. So the accused threatened to his father. At this, the deceased protested the act of the accused, and a quarrel ensued between them. But dispute was subsided, and at the time of evening, both accused and the deceased took their meals at the house of the accused. The deceased slept on the veranda. At about 11:30 p.m., by hearing the shout of deceased, the informant got up and saw the deceased Sanatan with injury, and the accused was standing near with him with a walla. When he got up, the accused threw the walla and ran away. Due to assault, Sanatan died at the spot. This incident was reported to the police, and in the due course, after completion of the investigation and the commitment, the accused put to trial. Let's see, then Lordship, paragraph 7. This is the only the PW2 on the basis of which the accused was, she claims to be the eyewitness. Paragraph 7, Lordship, kindly. PW2 deposed that on the date of occurrence, she was sleeping at the night. By hearing holla, she got up and saw the accused assaulting the deceased with a balla, and the blows struck his head and face. PW2 was subjected to cross-examination, but nothing was elicited from her to shake her veracity. PW2 is the mother of the deceased, and it is not likely on her part to leave the actual culprits implicate the innocent person. The accused PW2 were known to each other.
Grandmother
is the mother of the accused PW2. PW2 is the mother of the deceased.
Deceased. So is the grandmother.
Yes.
Yes. She's the grandmother of this accused.
Yes, Lord.
So there is no possibility of mistaken identity. The evidence of PW2 clearly shows that due to assault made by the accused, the deceased expired. The evidence of PW2 also received support from the other witnesses. PW1 deposed that by hearing hula of his son, he woke up and saw the accused standing with Hibala and his son laying with injuries. He chased the accused, but he ran away, throwing the bala at the spot. PW3 also deposed to that effect. PW4 deposed that being asked, he chased the accused. PW5 failed to support the case of the prosecution. And PW6 is the seizure witness, and PW7. The doctor examined Baisakhu and found no injury on his person. PW8 is that IO of this case. The evidence of PW2 and 3 reveals that the accused had found in the dead of night near Sanatan with Ebala, and Sanatan was lying with injuries. Admittedly, no other person was present at the spot, so the above circumstances not only corroborates the evidence of PW2, but point out to the guilty of the accused. In the decision of reported such and such lordship, their lordships held that it is established that the appellant was seen sitting with his wife Saraswati in his house till late night. On the following morning, Saraswati was found dead. This raises a strong inference that he must have been the author of the crime. In this case also, the evidence of PW1 and 3 shows that the accused was seen near the deceased being armed with a bala. The evidence of PW2 and the circumstances pointed out makes it clear, like crystal, that due to assault made by the accused, the deceased expired. Coming to the intention to commit the murder, next paragraph, Lordship. Coming to the intention to commit the murder, intention being a state of mind, it has to be inferred from the proof facts. In this case, the evidence shows that the accused dealt the blow with a bala to the head of the person who was sleeping, and this fact itself shows that the accused had the intention to commit murder. The decision reported in such and such lordship held that from the evidence on the record, it is clearly established that the respondent went to the house of the deceased armed with the kularis, shows his intention and premeditated motion to the murder of the deceased. Let's kindly see the deposition of PW2. PW2 has page 25, Lordship. Page 25. This is Sanatan is my son. I know the accused. Sanatan was murdered 2.5 years back in front of my house. We are sleeping at night. By hearing hula of my son, I got up and saw the accused assaulting deceased with a bala. The blow struck the head and face. I was examined by the police. Lordship, then cross-examination. I have 2 debris and one was burning inside the house. The deceased was sleeping at a distance of 10 to 12 feet from me. My husband had slept on the other side of me. By hearing the hula of my son, I got up. My husband also made hula. As soon as we got up, the accused threw the bala and ran away from the spot. This part is important, Lordship. The intention part is the accused never quarreled with the deceased and the relation between them was good. I do not know why they...
When you have a direct evidence, all this is irrelevant, sir.
But the intention part is not there. Lordship, I'm coming to the next part.
The man has died. Where's Mr. Intention not there?
Also,
just look at the post-mortem then.
Yes. Incised wound on the right side.
This PW2 was not examined by the police. He was not made in charge sheeted witness. He gave witness for the first time before the court. Lordship will cross-examine last part, page 26. I had not gone to the PS.
But she's a grandmother.
Not police raised me anything. For the first time, I'm deposing at the court. He has not made with the charge sheeted witness. Lordship.
She's a grandmother.
PW3, my lord.
She claims to be the eyewitness, but she has not made the charge sheeted witness by the police.
Read of PW3 also then.
With regard to intention, my lord. PW3. 3. This is my elder brother. I know the accused. He is also my elder brother. Sanatan was murdered about 3 years back at night. I was sleeping near my mother and the deceased was sleeping below the veranda. At evening, the accused, being drunk, came to our house and there was exchange of words between my brother and accused. Being asked by us, the accused went away to his house. By hearing halla of my brother, I got up and saw the accused standing near the deceased.
1 minute, there's some confusion here. Deceased is his elder brother.
Yes.
I know the accused, he's also my elder brother.
She is not the grandmother. This is my two brothers. Or you may kindly see, PW2 says, my lord, deceased Sanatan is my son.
No, look at the lower court judgment, sir. First paragraph.
That's, yes.
So the deceased is the elder brother.
That's probably not wrong recording.
Deceased and accused are two brothers, let's see.
Yes.
Oh, so the two sons.
Yes.
Of two sons of different brothers.
So the father quarrels with the mother, and then the quarrel happens between the two sons.
Two sons, and the elder son comes in. And there's about the intention part. He was drunk. He came home and fought with they had a quarrel. He went back and got the weapon of offense and then assaulted.
PW3 also not examined by the police, nor has been made by PW3 also not by the charge sheet witness. The first time he's also depositing before the court.
So what, sir? There must be something in the cross-examination that tells us that they are lying.
And the nature
Except saying that they were examined for the first time in court, you're not showing us that they're speaking falsehood.
And the PW2 in evidence that said that it was a night and there is two burning of two debris.
They're all related. How can they make a mistake? They're all staying in the same house. One person throws the bala and runs away means there's no doubt as to who the person is. They're all so close. They're all
and the
related.
nature of injury
his own
also.
brother. He will not know his own brother. No stranger. What is the alternative theory? Somebody else came in. You must have an alternative theory. You have to suggest that somebody else came into the house and killed my father. Killed my brother. Sorry.
He has already undergone the period of more than 9 years.
What does it mean, sir? You have to argue in law. For a 302, 9 years, court will release in 9 years. For a 302. Can you read the postmortem, what it's worth? The doctor.
Dr. My lord. In para 6 of the judgment, my lord, it has been recorded. Exhibit 6, the postmortem report was marked under section 32(2) of the Evidence Act as the doctor was dead. Exhibit 6 reveals that the doctor had held postmortem over the dead body of deceased Chalu on 14/6/2003 and noticed an incised wound on the right side face starting from just above.
Sorry, which page are you reading? Sorry?
I'm sorry, I'm reading from the judgment, my lord. Para 2.
No. The
Evidence.
Deposition. Yeah.
Yes.
They seem to be cousin brothers. Huh?
Yes, sir.
If you see PW1, who's the informant, deceased Sanatan is my son. I know the accused is my
He's
nephew.
my nephew. Here, my lord, witness number 7, he had examined the, my lord, the accused, because the person who had conducted the postmortem died. That is the recording of the trial court.
Oh, I see.
But the nature of injuries, Lordship may see, para 6, page 2 of the judgment. Incised wound on the right side face, starting from just above the right eye, from middle and opened, that the injuries are antemortem in nature, and death was due to head injury involving fracture of skull and laceration of brain matter.
Doctor who committed postmortem, he has not examined.
He died, sir.
He died.
Fracture of the skull.
Fracture of the skull. And two
Brain matter came out.
Two post-occurrence witnesses were asked to chase the accused. They chased and he fled away. PW 3 and 4.
Yes, anything else?
Unless PW3 also stated in cross-examination that both the accused and the deceased, they have good relationship. 2 and 3 in cross-examination both have stated that they are in good relationship. Cross-examination. There is no quarrel, even a quarrel between the accused and
No,
the
there was a
deceased.
quarrel, sir.
Yes.
Actually, the previous day, that's what the judgment starts with. The mother quarreled with the father and left the house.
The accused protested.
That's right. And the brother, the deceased, protested against the accused protesting.
And in the night, on the same night, they both of them eat the meal together.
That's all right. You are harboring the intention to do something in the night, which nobody's aware of.
So, lastly, my only submission is the intention part is, let's kindly consider, and he has already undergone the period of more than 9 years. That is my submission.
You're repeating that, sir. As a lawyer, how do you repeat that argument? Huh? You're repeatedly arguing. What are you arguing? Just no, don't be sorry. I'm just curious to know from a legal point of view, what are you arguing? What are you arguing? Why are you repeating that? Anyway. What is reserved?
Published. Supplementary list item 24. Supplementary list item number 24.
24, we received information that appellant number 3, Guru Bhumia, has died in the meantime.
All right.
On 8 to 2008.
All right.
And two appellants, my lord.
No, that is already recorded by us in the previous
Yes,
order.
yes, ma'am. Yes, ma'am. That is recorded. Even appellant number. No,
Appellant
in the
number 2.
meantime, one more also he has died, my lord. Guru Bhumia and Chandra Bhumia, 2 have died, my lord.
So we had directed notice to appellant number 2. What happened?
Appellant 1 and 3.
Madam,
Yes.
this is already noticed in our previous order. Please read the 7th April order. Have you got the order of 7th April? Have you got a copy of the 7th April order?
No, my lord. I
Just
think
show her the order.
Nothing is written.
That's all right. We'll just give you the order. Not bad. What about the legal aid counsel? Who's been assigned?
Okay.
Where is she?
Yeah, we can pass.
No problem. Yeah, we'll pass. We just pass it over, just ask her to be present in court. Pushpa Ranimar. We'll pass it over. There's a legal aid counsel. Her name is shown in the list, but she's not here.
Supplementary list item 25.
Please, Your Lordship. My Lord, on the last.
A report was called for, it has come, madam.
Flag K. Yes, ma'am. Your Lordship, may kindly see the judgment, my Lord. The background over here as recorded in the judgment and from the deposition also, my Lord, if that is taken to account, my Lord, it started all from a quarrel, my Lord. Your Lordship, may kindly see page 2, my Lord, internal page 2, the judgment, second paragraph.
Flag K.
Second page of the judgment, my Lord.
Yeah, one. Staying in his house. All right. Right. Sorry, what were you saying, sir?
My Lord, second page of the judgment, Your Lordship, may kindly see. It all started from a quarrel, my Lord, between the family members. Both are accused and the deceased, both are cousins, my Lord.
Just read it on 20.
Yes, my Lord. On 23/24/4/2005, at about midnight, the deceased Basant Kumar Naik quarreled with his wife Gauri Naik, and during such quarrel, the accused, who is the cousin of the deceased Basant Kumar Naik, came there and challenged Basant Kumar Naik for picking up quarrel with the family members regularly. It is alleged that due to such challenge, there was exchange of hot words between Basanta and the accused, whereafter the accused went back to his house and again returned with a sword and assaulted Basanta with the said sword. As a result, the deceased sustained several bleeding injuries on his person and died at the spot. During, Your Lordship, towards the last, my Lord, during course of investigation.
Yes, yes.
During course of investigation, the IO examined the complainant and the witnesses, arrested the accused, held inquest over the dead body of the deceased, prepared the inquest report, seized the blood-stained and sample earth from the spot, seized the wearing apparels of the accused, dispatched the body of the deceased to SDH Karanjia for post-mortem examination. While in police custody, the accused admitted before the IO as well as the witnesses to have committed the murder of the deceased and further disclosed to have concealed the said sword in the straw heap in his body. Saying so, he led the police and witnesses gave discovery of the sword, which was seized by the IO. The investigation that followed ended in submission of the charge sheet under Section 302 of IPC against the accused, hence this case. Lordship, may kindly see the deposition, my Lord. My Lord, admittedly, there are 3 eyewitnesses. What I want to submit before Your Lordship is, my Lord, the entire case taken as it is at best a case under 304 Part 1, my Lord.
First read the
deposition.
Postmortem. No, yeah. The doctor's evidence then. Let's see the doctor's evidence.
Yes, my Lord.
PW8.
PW8, my Lord. Page 43 of the paper book.
Yes.
On 24/4/2005, I was attached to SDH Karanjia as assistant surgeon
And on that day, on police requisition, I conducted autopsy over the dead body of Basant Kumar Naik, son of Hari Naik of village Tatto, PS Koranjia, and found as follows. External appearance: stout body, rigor mortis present, all 4 limbs including fingers, multiple injuries present with clean cut margin under both the deltoid region, left side of the neck, left thigh, dorsum of right palm, right axilla, and contact abrasion on the chest. Cut wound on the left arm, deltoid region of the size 7 into 3 into 2.5 inches horizontally situated and have felling out medially by contact abrasion 3 inches length. Corresponding fracture of humerus present. Similar cut wound present on the right deltoid region of size 7 into 3 into 3 inches and laterally underlying humerus fracture present. 2 definite cut wounds whose margins are adhered together present on the left side of the neck of size 6.5 into 3.5 into 2 inches and partially mandible is cut. Left side major vessels of the neck.
Happened?
My lord.
Do you know what has happened?
Yes, my lord.
What?
My lord, there are multiple injuries.
Injuries? The man has gone berserk. The man has gone berserk. He didn't know how to stop his sword.
My lord,
he's slashing all over the place.
My lord, there was, I would like to place some judgments, my lord, where there were multiple injuries, but the same has been held to be under 304 part 1, my lord.
Really? Okay. We'll just keep 2 tabular columns and compare the injuries in that judgment to the injuries here.
I will do that, my lord. I will do that.
All right. Which one? Which judgment, sir?
Multiple injuries, my lord. Serial number 1, my lord.
All right.
Page 1. Para 2 is the fact, my lord. I will read out. The occurrence which gave rise to the present appeals took place on August 7, 1972, a little over 10:30 p.m. Purushottam Lal, according to prosecution, who was fatally injured in this occurrence, had a few days prior to August 7, 1972, earned a prize in the amount of rupees 5,100 in a private lottery. Along with some other amount which he had with him, it is alleged he usually kept rupees 8,000 in his pocket. On the date of occurrence, deceased Purushottam Lal, accompanied by one Om Prakash alias Pashi, visited Jyoti Cinema in the second show. Accused 2 Rajkumar, who was also in the theatre at that time, at about this time, accused 1 Wazir Chand and respondent 1 in Criminal Appeal 5975 and Joginder Singh were seen conversing among themselves in the veranda of the theatre. The second show was over around 10:30 p.m. Deshraj PW3, who was also enjoying the picture, came out of the theatre and proceeded towards his house. And on the way, he crossed accused 3 Joginder Singh, whose clothes appeared to have been stained with blood. Proceeding ahead, Deshraj heard a shout and rushed in that direction. He found Purushottam Lal injured lying on the ground and he inquired from Purushottam Lal as to what happened, whereupon Purushottam Lal told him that Wazir Chand hawker doing business near Prem Bus Company injured him with a knife, and at that time Joginder Singh, son of Nathu of Girt, Sakna and Rajkumar, brother of Wazir Chand, were with him, and they bade him and information should be given to his relatives. Deshraj went to the house of Purushottam Lal and informed his wife Srimati Pushpa, PW5.
No, you don't have to read the entire thing like that. Just come to page 134.
Para 25, my lord.
No. Please come to page 134.
Yes, my lord.
The injuries are set out.
134, my lord.
The 4 injuries are set out.
Yes, my lord. 4 injuries are set out.
In her opinion, just see the bottom. In her opinion,
injury 1 was sufficient in the ordinary course of nature to cause death.
Just a minute.
Yes,
therefore, in that case, of the 4 injuries, only 1 was serious. Whereas here you come to your page 44.
My lord, that was page 44, my lord, last para. The cause of death is due to hemorrhage shock due to homicidal cut injuries by a sharp cutting weapon.
Injuries.
Yes, my lord.
So it makes a huge difference. Makes a huge difference.
My lord, if your lordship could see, majority of the injuries over here are abrasions.
No.
Yes, my lord.
Please.
Injuries on neck.
The main
multiple cut injuries on the neck.
multiple
Sir.
cut injuries on the neck.
And then 2 definite cut wounds to the left side of the neck.
Injury on the head, my lord.
Also. And then humerus
Injury number-
fracture.
Injury number C, my lord.
Yes. Too many injuries. What about the other eyewitness statements?
Eyewitness statements, your lordship may kindly see. Page 28, my lord, PW1 wife. Page 28, my lord, of the paper book.
Yes.
The accused is my brother-in-law, husband's younger brother. My husband died about 1.5 years back. On the date of occurrence, my husband returned home at night and quarreled with me and other family members for not preparing curry in the food. During such quarrel, the accused came and intervened, but my husband asked not to intervene as he was quarreling with his family members. On our advice, the accused went away to his house. Thereafter, the accused again quarreled with us. During such quarrel, the accused came with a sword and dealt blows on the neck and shoulder of my husband. As a result, my husband died at the spot. On my protest, the accused also threatened to murder who would come to him. On his allegation, I lost On this allegation, I lost a written report before the OIC, and in the cross-examination, my lord, there is no, except that Exhibit 1 was written by me as per the dictation given by the police. The FIR, Exhibit 1 is the FIR. It is not a fact that it was dark night, and your lordship may kindly see the father's deposition, my lord. Another eyewitness at page 35. Cross-examination, same thing, my lord. But on cross-examination, if your lordship could see page 36.
Suggestion was given that there was a tussle between the accused and the deceased, and he fell down and he sustained injuries and died out of that. That suggestion was also not. It is not a fact that my son was armed with a bala and at the time of this incident. It is not a fact that my son attempted to assault the accused with that bala, for which there was a tussle.
Let me read. I'm sorry. On the date my son takes liquor, he used to quarrel in the house. When my son quarreled with his wife and me, I came out of my room, and while standing in front of the room, the accused came there. When the accused challenged my son for such quarrel, my son pushed him out of our house, but immediately thereafter, the accused again came to our house and assaulted my son with a sword. I have seen the accused holding the sword. The length of the sword will be around 2 cubits. It is not a fact that my son was armed with a bola at the time of this incident. It is not a fact that my son attempted to assault the accused with that bola, for which there was a tussle, and in course of such tussle, my son sustained the injuries and succumbed to the same. It is not a fact that the accused has not assaulted my son with a sword. So, my lord, there was a quarrel that started from a quarrel, my lord. So I put my case within 304 part 1. That is what only thing that I can put before your lordship, my lord.
Oh. All these are 304 part 1 judgments.
My lord. Yes, my lord.
All right. You want to add anything?
My lord, in view of the ocular evidence of PW1, 2, and 4, the wife, father, and mother, and PW3, she is a post-occurrence witness. After hearing halla,
PW3 is what? Who?
PW3, my lord. She is a post-occurrence witness. After hearing the halla of one of these eyewitnesses, she came and found the accused standing at the place, and the leading to discovery, my lord. As per the evidence of the accused himself, the weapon
That's
of
not relevant because
weapon
direct
of
eyewitnesses.
And my lord, the chemical examination report that also suggested the human blood found on the weapon of offense is not the same of the accused. That's a 4 statement.
My lord, for if your lordship considers benefit under 428 for sentence under the.
Yeah. Orders reserved.
Supplemental list item 26.
Your Lordship kindly says the order dated 9/2/2022.
My lord, I am appearing on
I
behalf
am
of
for the respondent. My lord, I am appearing for the appellant, my lord.
appearing on behalf of Sri Ravi Raghavan.
If your Lordship will come to the last order dated 9th February 2022, your Lordship has heard that as there is a proposal for transfer of this present appellant to the Tata Steel Long Groups. The respondent were taken over by Tata Steel Long Products Limited, and the takeover process is still not over, my lords. It is in the stage of the final preparation of the balance sheet and the contingent liabilities, the determination of the contingent liabilities, my lords. So it will take another 1 month time, I think, for the entire process to get over, so that thereafter the proper party can then be substituted for presenting the matter for your lordships.
All right. Consequently, the respondent informs the court that the process of takeover of the respondent by Tata Steel Long Products Limited is still in progress and is expected to be completed within a month. List on 11th August.
I'm deeply obliged.
Obliged, my lord.
Supplementary list passed on matter item 15.
May I please, Lordship may kindly peruse order dated 11th of March 2022. Your Lordships have framed the questions of law, my lord. May I please the question of law?
Yes, please. Yes.
Whether the assessing officer AO, CIT appeal, and IT-80 were right in disallowing commission expenses and in applying section 37 of the IT Act. Here the facts of the case, my lord, is the petitioner is a manufacturer of polypropylene bags, my lords. And while it was running its business of manufacture of woven sacks and bags, my lord, it got an order from China for supply of iron ore fines, my lord. And if your lordship would, at this juncture, kindly turn to running page 30, my lord. It's a part of the assessment order, which was the reason for which this particular commission was paid and under the circumstances in which it was paid, my lord. Lordship got it, my lords. Running page 30, internal page 2.
Yes.
That's a part of Annex 2, that's the assessment order, my lords.
Yes.
Paragraph 4, my lords.
Yes.
While examining the case, it was noted that the SSC has debited a sum of rupees 53,49,790 under the head commission in subhead administrative and selling expenses in the schedule to the profit and loss account. In the immediately preceding year, the expenditure claimed was under this head was 11,11,362. While this office questionnaire, the SSC was required to file details or copy of the account of the commission paid and also give justification for the same. In support, the SSC filed a copy of the commission account, which is placed on the record. While justifying the commission expenses, it was submitted as under minutes. The company saw a good potential in the trading activities of IOF, that is iron ore fines, which are mainly exported to China. The technology for using IOF to get FE of 50 to 70% was available in China only. Previously, IOF, known as Morum, was being used to make village roads in India. But it was known to the company that this trading business is temporary in nature and is mostly dependent on the government policy. Now this business is totally stopped due to the imposition of 30% duty by the central government. Therefore, the company took the decision to take all measures to do this business as maximum as possible within a short period. The company depended on commission agents for its source of materials and for its sale. The area where the materials are available are very much dangerous, as a lot of masked activities are there. The company had to open offices in various places where materials are being purchased or sourced, and for the staying of the staff, rented houses were taken without of which it could not have been possible to do that business. Without recruiting extra manpower for this trading business, due to temporary in nature, the company paid extra remuneration to the existing employees of the new work and made the work done. So the staff expenses increased. Then, my lord, the SSE, he gives the list of the entire commission paid to various various persons, my lord. That is at page 31 and page 32, my lords. Then paragraph 4.2, why it was disallowed, my lords. A perusal at page 32, my lord, paragraph 4.2.
Yes.
A perusal of the copy of commission account would reveal that the same has been paid in general to individuals who are family members and relatives of the directors of the company who hardly have any expertise in iron ore. It has not also been proved that on what purchases this commission was paid. The commission has been paid in round figures and in one lump sum without specifying the rate of commission paid and also the specific purpose, specific purchase. Then your lordship may turn over the page, my lord. Then he says, my lord, that this is not
modern foods makes breads.
Sorry, my lord?
Modern
modern food makes bread, but modern food was a person who had given its employees for this sourcing of iron ore. Because for this sourcing of iron ore, my lord, in my humble submission, my lord, and as has been noted, no expertise is necessary. They have to only go and contact the mine owners. They have to go and contact the various raising contractors. And my lord, on this, the entire amount was subjected to TDS, and all these persons, they filed their individual returns and paid taxes, my lords. And that was also noted by the IT-AT, my lords.
Yeah.
Except for, my lord, two instances, that is totaling to 23 lakhs 41 at page 4.4, paragraph 4.4, my lords, totaling to 23 lakhs 41,245 was allowed as genuine commission expenses, and the difference of 30 lakhs 8,545 was disallowed, my lord. Then a lordship would appreciate that this was confirmed in appeal. Then I moved the tribunal. And in the tribunal, my lord, your lordship would appreciate, I'd only take your lordship to page 42, my lords.
Yes.
Paragraph 5 of the tribunal's order, my lords.
Yes.
Lordship, page 42.
Yes.
May I please?
Yes, please.
Undisputedly, the SSE company has paid commission to the individuals to the tune of 53 lakhs 49,790 during the year under assessment, and the details thereof is reproduced hereunder for ready perusal. Then he notes down the details, my lord, at page 43, 44, and at page 45, paragraph 6. AO primarily made addition by comparing the amount of 53 lakhs 49,790 debited under the head commission with immediate preceding year in which the SSE had claimed 11 lakhs 11,362. However, it is undisputed fact that during the year under assessment, gross turnover of the SSE is rupees 5278.63 lakhs, on which the SSE has paid commission to the tune of 53 lakhs 49,790, which is 1.35%, my lords. Then your lordship may skip over this, my lords, but come to paragraph 8, my lords. When the SSE company has already incurred huge expenditure on the head of salary, bonus, rent, etc., to its staff engaged in the iron ore business, it is highly improbable, my lords, to pay the commission to the directors and their family members or relatives, particularly when the SSE has failed to bring on record their expertise to render the service, nor was there an iota of evidence as to what service they have rendered to enhance the business of the SSE. Merely because of the fact that the SSE has deducted TDS, the commission cannot be allowed under the given circumstances. Moreover, it is rightly brought on record by the learned CIT appeals that the SSE has failed to specify for which particular sale is effected by director and family members of the SSE, and the commission has been paid. My humble submission, my lord, would be that first, there's no expertise necessary for the type of job which was being executed by these individuals, my lord, because the only thing which was necessary was to contact various places and to take the iron ores, my lord, and to in order to meet the export requirements.
But Mr.
Number
Farah,
two, my lord, since
it can't be mere coincidence that commission is paid to 7 individuals. For 3 of employees and 4 are relatives.
Now, this, my lord, this is, my lord, in my humble submission, a business exigencies as has been noticed by the Honorable Supreme Court. May I just place that decision before your lordship?
Yes.
This was under the 22 Act, my lords. If your lordship would kindly turn to page 3 of the judgment, my lords.
Yes.
Lordship got it at page 3, my lords?
Yes.
The lordships have quoted section 2, 10 to 14, my lords, which in my humble submission is almost parametria to section 37, my lords. At this juncture, may I just place 37 before I come to 10 to 14, my lords?
Good, that's that.
Section 37. Section 37.
Yes.
Any expenditure not being expenditure of the nature described in sections 30 to 36 and not being in the nature of capital expenditure or personal expenses of the SSC laid out or expended wholly or exclusively for the purpose of businesses or profession shall be allowed in computing the income chargeable under the head profits and gains of business or profession. This was somewhat parametria to the 22 Act. If your lordship would kindly turn to page 3 and compare it with 10 to 14, my lords. Any expenditure, your lordship got it?
Yes.
Not being in the nature of capital expenditure or personal expenses of the SSC, laid out or expended wholly or exclusively for the purpose of such business, profession, or vocation. And this is the clause which, and the section which the Honorable Supreme Court was considering, and your lordship would come to the last paragraph of that page. It begins with we.
Yes.
We should make it clear that in this case, we are not called upon to decide whether the income tax officer could exercise the power he exercised under section 10 to 10 of the Income Tax Act. The question referred by the tribunal and answered by the High Court only deals with the claim of deduction of the amount paid to Sri J.P. Vaish under section 10 to 14 and not 10 to 10 of the Act. Then lordship turn over the page. The question as to whether an amount claimed as expenditure was laid out or expended wholly or exclusively for the purpose of business, profession, or vocation as required under section 10 to 14 of the Income Tax Act has been decided on the facts and in the light of the circumstances of each particular case. But as observed by this court in Swadeshi Cotton Mills Company Limited versus CIT 67 ITR page 57 Supreme Court, the final conclusion on the admissibility of an alliance is one of law. In the present case, both the appellant assistant commissioner and the appellate tribunal rejected the view of the income tax officer that the rate of commission paid to Sri Vaish was not fixed on account of the business consideration, but there was some commission paid to Sri Vaish was not fixed on account of the business consideration, but there was some, I'm sorry, I'm repeating it, some collateral reasons. But considering the practice in similar business concerns, the appellate assistant commissioner expressed the view that the rate of 12.5% commission was reasonable and the alliance was therefore restricted to half of the amount claimed by the SSC. The view of the appellate assistant commissioner has been affirmed by the Income Tax Appellate Tribunal. The case of the SSC, however, is that a higher rate of commission of 25% was fixed for Sri J.P. Vaish because the mill was old and dilapidated and it never made profit of even a lakh of rupee in the past, and that the rate of 25% was fixed in order to create special interest in the general manager for accomplishment of the task entrusted to him. In our opinion, my lord, I emphasize on this, neither the High Court nor the appellate tribunal has applied the proper test in this case. as pointed out by this court in Commissioner of Income Tax versus Walchand and Company Private Limited, 65 ITR 381 Supreme Court, in applying the test of commercial expediency for determining whether an expenditure was wholly or exclusively laid out for the purpose of business, the reasonableness of the expenditure has to be adjusted from the point of view of the businessman and not of the income tax department. It is, of course, open to the appellate tribunal to come to a conclusion either that the alleged payment is not real or that it was not incurred by the assessee in the character of a trader, or it was not laid out wholly or exclusively for the purpose of business of the assessee, and to disallow it. But it is not the function of the tribunal to determine the remuneration which, in their view, should be paid to an employee of the assessee. It was also pointed out in the case that an employee in fixing the remuneration of his employees, employer in fixing the remuneration of his employees is entitled to consider the extent of his business, the nature of the duties to be performed, the special aptitude of the employee, future prospects of extension of the business, and a host of other related circumstances. In our opinion, the principle of this decision applies to the present case, and it must accordingly be held that in the circumstances, establishment by the decisions applied in the present case, and it must accordingly, established by the assessee that the entire amount of 75,465 paid by the general manager, Sri J.P. Vash, was an account laid out or expended wholly and exclusively for the purpose of business or assessee. My entire endeavor before your lordship would be not that the business expediency of the assessee was such that it was a temporary nature of business, my lord. It was not his main business, my lord. His main business was manufacture of PP oven sacks, my lord. So when he got an order from China, it was a temporary order, and it had to be accomplished within a limited period of time. And no one, in my humble submission, would be more dependent than the employees who were already there with the employees and the relations who are directors.
Not for commission. Payment of commission.
Payment of commission. No,
they obtain the business for you, then you pay commission.
No, my lord, they are generating the business. No. Otherwise, my lord, without these people, my lord, your lordship would kind of
employees are not going to be able to find some buyers in China.
No, they are not finding buyers, my lord. I got the order from China. What the employees are doing, my lord, they are going and, my lord, they are contacting the mine owners, my lord, for getting the iron ore fines to export of China, my lord. The SSC has got an order from China, my lord. My lord, my humble contention, my lord, neither the employees nor any of those persons who have paid commission had any direct link for procurement of an order from China, my lord.
So then what is commission called?
Commission, my lord, is for arranging this particular iron ore fines from the mines. No. For purchase of my iron ore fines to deliver to the export house, my lord, for export of China to China, my lord.
Fine. It's all this is, there are obviously no contracts of such commission.
And your lordship would appreciate, my lord, this would amount to double taxation in my humble submission, my lords, because TDS has already been deducted.
That's okay. That's a known device.
And, TDS has, your lordship would appreciate, not TDS has already been deducted. And it has not been disputed by any of the authorities, three authorities, my lords. And the fact that these individuals have shown this as an income, this commission has...
It's all right. Doesn't still mean that you get away with showing all of this.
Otherwise, my lord, if this particular commission paid to these individuals are disallowed in my hands, my lord.
No, entire thing has not been disallowed. Only a part.
Even that part, my lord, for those 7 individuals, your lordship would appreciate TDS has been deducted from the entire amount of commission, and that has been noted by the tribunal.
Correct.
And even if they are these 7 individuals for which they have disallowed this amount of 30 lakhs or more, my lords, then also TDS has been paid, and this amount has been shown by those respective individuals, my lord, in their returns, and taxes have been paid, due taxes have been paid, my lords.
All right. We're not inclined.
And your lordship would appreciate, my lord. And your lordship would appreciate, my lord, I had... humble prayer.
Yes.
None of these individuals, even though they were said that these individuals were paid, my lords, commission, have ever been summoned to find out whether this is a fact or not.
No, why should that need not be disbelieved that you paid the commission. The question is, can you claim it as an expenditure, this kind of payment?
No, this kind of payment, my lord, was in furtherance of my business.
That's okay. That they have a right to determine how much of it is genuinely for business and how much it is not.
But may I just humbly pray, my lord, if the lordship would set it aside, let the tribunal apply its mind again.
No, not
or at least the CIT appeals should apply its mind to find out, my lord, whether, my lord, if what has happened, my lord, in this case, the SSC has procured an order from China.
Yes.
These individuals were not in any way connected in procurement of the order from China.
We take your argument that for sourcing the fine, iron ore fines, their services were required, and you are paying them commission for having obtained or procured the iron ore fines.
Otherwise, without their help, without their efforts, my lord, I would not have been in a position.
That is, of course, that is something that we don't think the
and this
went wrong on that.
Lord, and my second humble submission would be, Lord, these individuals were paid salary for their work in the manufacturing unit that is PP Oven Sachs, my lords. This was an additional work which they did, my lords, because of the temporary nature for that particular assessment year, because after that it stopped because of the high rate of duty, my lords. So these for that special work, my lord, which was entrusted to them for the assessment year 10-11.
For the certain case, the question is that believable or not? The AO has taken a call. I think the CITA and the tribunal were not in error. So that's the end of the matter.
My lord, may I just humbly pray, my lord, at least let that fact, my lord, at least these 7 individuals who have paid, who have...
No, we'll note all your arguments. There's no question at all. We'll, of course, note all your arguments. The appeal is dismissed. We'll pass the detailed order. Hmm. Hmm. Assigned the matter is not present. The registry will inform her to remain present on next date. List on 21st June. Sorry, it's a 28.
May I call weekly list. Weekly list old matter item number 1.
Flag H.
Weekly list old matter item number 1.
Aravind Behra and Hanu Mandal have died. A report dated 17th. This must be 21 is an old. When did the last year? In terms of the report submitted by the IIC Kadisuriya Nagar PS on 17 January 2021, two of the appellants, there are only two appellants here. No, one of the appellants, that is Aravind Behra. Oh, there's already an order. 2012-2017. Yeah, 2012-2017 is already abated. Oh, pardon my purpose. Okay. Hmm. 11 of 2001, 14 of 2000, they're all connected, is it? Govinda Behra. See, pursuant to the orders passed by this court earlier, a report has been submitted by the IIC Kavisuri Nagar PS on 17th January 2021, confirming the well-being of the appellants. Today, none appears on behalf of the appellants. Registry will send copies of the paper books. Why are there two appeals by the same appellant? Why are there two appeals by Jayadev Behra? I mean, they are two different people.
One jail criminal appeal and one criminal appeal, my lord. So they have been analogously tagged.
Oh, okay. Copies of the paper books to the Secretary, High Court Legal Services Committee, who will appoint two legal counsel, two panel counsels, one each, for the appellant Jayadev Behra and the appellant Govinda Behra, who have experience of not less than 10 years, or of not less than 10 years standing. The said legal aid counsel will be provided with the paper books and will contact the appellants for instructions. This is for hearing on 30th June, 30 June.
Weekly list item number 2.
In item number 2, I have been engaged as the amicus query in this case, and I have been directed to contact with the, kindly see the order of 17/12/2020.
Sorry?
In that last para, 17/12/2020. In this case, I have contacted with the telephone number provided in that case. I have contacted the accused. With much difficulty, he replied me, one of his, that phone number, he replied me that he wants to retain his original counsel.
No. We are not going by all that. You carry on, sir. The man will find numerous excuses for adjournments.
I am not asking for adjournment.
So carry on. Carry on, sir.
It is a case under section 302 IPC.
Right, sir.
The order passed on 21/9/2001.
Yes.
Passed by the additional session judge Rairangpur.
Right.
And wherein the sentence for life of imprisonment has been awarded by that court, madam.
Right.
Along a trial court. And the date of occurrence is 1910-2000, and on that the place of occurrence is village Barikrama field. The PW1 who happened to the one of the chowkidar and the son of the deceased Kinni Bewa, he lost the complaint. May I read that brief facts which have been
please? Para 2 you read.
Yes. Briefly stated, the prosecution case as disclosed from the FIR Exhibit 1 lost by one Jagabandhu Naik PW1 is that Jagabandhu was the Gramaraki of Badampad PS on 1910-2000 at about 7 am. Deceased Kinni Bewa went to tend the cows to Bargimara field, and the informant Jagabandhu went to Hatabododa for medicines. His daughter and son were in the house. At about 12 noon, Jagabandhu returned from Hatabododa to his house, and he found his mother Kinni Bewa was not returning from the grazing field. He searched for his mother and found near the field of Jodapokhori that the accused were assaulting on the head of the deceased Kinni Bewa by means of the lathi. By chasing her at about 1:30 p.m., the mother of PW1 was raising halla by saying Morigali, and thereafter she fell down while the deceased was lying on the ground. At that time, the accused dealt 2 to 3 stone blows on her head, by which she died. When the informant asked the accused as to why he killed his mother, at that time the accused raised him to assault by holding one stone, and out of fear the informant ran away towards Kusumi Road. The informant reached in the village and told the occurrence Singari Maji, Durgacharana Maji, Mora Maji, Durjodhana Patra, Ratna Maji, Raghunath Maji, and many others. He also told the occurrence to his son and daughter. Hearing the occurrence, the witness went to the spot and found Kinni Bewa was lying dead. At about 2:30 p.m., his daughter Kumari Anita Putti told him that the accused made an extrajudicial confession before her by saying that he had killed Kinni Bewa much before the occurrence. There was a quarrel between the deceased and accused for landed properties. On 1910-2000, the informant lodged the written report at Badampad PS. The OIC registered the case under Section 302 IPC. In course of investigation, PW11 made...
All right. Now we can read PW1.
Yes.
Jagabandhu Naik.
Yes.
Page 33.
I know the accused. I also know the deceased Kinni Bewa, who was my mother. The accused is the son of my elder brother. The occurrence took place on 1910-2000 on a Thursday. My mother, deceased, had been to tend the cows on that day, and I had been to bring medicines from Hatabododa. Then I returned to my house at about 2 p.m. I was going to village Bargimara. On my way near the village Jodapokhori, in a field, I found my mother and the accused were tending the cattle. Then I found suddenly the accused dealt lathi blows on the body of my mother, by which she fell down. Then the accused dealt stone blows on the head of my mother. I saw the occurrence from a distance of 20 feet. Seeing the assault, I objected.
So 1 minute, there is some confusion here.
Yes.
He says, I know the accused, I know the deceased.
Yes.
Deceased Kinni Bewa was his mother.
Yes. Here,
the accused, 1 minute. The accused is the son of my elder brother.
Yes.
So the accused is not, he's a
he's the grandson of the deceased.
Deceased.
Yes.
So the grandson kills grandmother.
My lord?
The grandson has killed the grandmother. The accused was the grandson of the of the deceased.
Of the deceased.
Yes.
Then I village different way. Out of fear, I ran away to my village on a different way. I told the occurrence to my daughter, Anita, and my son, Ashok. Thereafter, I told the occurrence to Samai, Singari, Durga, Nimai of my
How old was the accused when this happened?
That time, the appeal has been written as his age is 40.
He is now 60-year-old.
He's now 60, is it? Achha.
He will be now 60-year-old.
Oh. All right.
Police came to my house at about, with cross-examination. Village Bagimora is a distance of 2 kilometers from my village. If one will go by cycle, Bagimora is at a distance of 2 kilometers from this spot. Sometimes 4 to 5 persons were tending their cows in one place. At the time of occurrence, the paddy plants were in a height of 6 to 8 inches. The place of occurrence was slide up and down. At the time of occurrence, my mother was raising halla. The accused was assaulting my mother by running behind her. The accused had only dealt 2 lathi blows on the head of my mother. I was suffering in malaria, and for that I brought medicine from the medicine store on the date of occurrence. Before the occurrence, I had also taken medicine for malaria. It is not a fact that I had not been to the spot due to malaria and deposing falsehood. The ASI Suleipat OP arrived at the spot, hearing the occurrence from me at about 12 midnight. OIC Badampar PS came to the spot for inquiry. At the instance of police, I watched the dead body along with other constable of PS. I have enmity with the accused for the landed properties. In this case, my lord, the learned trial court mostly relied upon the PW1, who claimed to be the eyewitness to the occurrence, and the medical evidence of PW6, who is the doctor who conducted the postmortem.
Let's read him. Let's read him.
That is page 23, my lord.
Yes.
Of paper book.
Yes.
On 2010-2000, I was in my present post. On that day, on production of dead body of Inibewa on police requisition, I had conducted the postmortem examination over the dead body and found as follows. Dermis peeled up on left cheek and abdomen at places of size 2 inch into 1, 2 lacerated and crushed injury at left ear. 2/3 of the lower portion of the latter is crossed with fracture of mastoid process of left temporal bone. 3. Multiple crossed and lacerated wounds situated at temporal and parietal region of the left side collectively measure 4 into 4 inches with underlying fracture of bones, though which brain matter has come out. Dissection of brain cavity is full of blood. Brain matter corresponding to injury number 3 is paced with bone spicicles and to external injury. Fracture of right parietal bone found with external hematoma. All the injuries are antemortem in nature, cause of death due to shock out of hemorrhage and neurogenic origin due to injuries. Time of death is within 24 to 48 hours at the time of examination. Exhibit 3 is my report. Exhibit 3 was signature. The injuries might have been caused by lathi blows and stone blows. On query of the IO, I opined that the injuries might have been caused by lathi blows and stone blows. the said lathi and stone were produced before me. The details of the
So what do you
lathi-
want to argue, sir?
Sir, and here, even if assuming that PW1 is the eyewitness and seen the occurrence, my lord, he himself says that I have enmity with the accused, but the accused has not enmity to his grandmother. And in the paddy field, my lord, in paddy field, the PW1 himself says that there are other 5 to 6 persons were tending the cows. And in this case, he says in his statement that the accused attacked her mother from the behind while the deceased was running. And when he fell down, he he attacked dealt with stones. And in this case, the learned trial court, and he's in his affair, he's categorically stated the affair is at page 24 that has been written in Odia. In the whatever he stated, he said that in the affair he stated that he was, when he came to the house at 12 p.m. after taking the meal, he went to the other village for collection of information as a chowkidar of that area, my lord. Thereafter, he found these happenings.
What is that? All right.
But while he returned from the house to the house, he came along with the entire couch, and he instructed the PW2 to enter the couch into the cow shed, my lord. If a person and he said that his daughter says that he confessed the guilty before her. But in the affair says the accused came and told her daughter that Je toro nana mori jaichi, your mother has been expired. In the affair he has written. Thereafter, this has been after 10 months of the trial, this has been yet another case. So far as the enmity is concerned, motive, here is no motive, my lord. No motive, intention to kill his grandmother. Even if assuming that there was some quarrel between the grandmother and the grandson, then there may be a sudden provocation, my lord. In his statement, he said that both were tending the cows. And all of a sudden, he attacked the informant's mother, her grandmother, his grandmother.
That's it.
My lord. PW1, my lord, Jagabandhu Nayak is the informant, he is the eyewitness. PW2 is Anita Pusti. She is Anita Purti. She is the daughter of PW1. So her grandmother had died. She says, my lord, the Accused is my agnetic brother. PW1 is my father. The deceased is my grandmother. About 10 months back, the deceased had been to tend the cows to the field. My brother Ashok had been to Chuapani. I found the accused was coming with our cattle from the grazing field at about 2 p.m. Seeing him, I asked about my mother of my father. Then the accused on my question told me that he killed the deceased and he directed me to fasten the cow in the cowshed. Thereafter, my brother Ashok came. I informed the incident to my brother. In the meantime, my father came and I told him about the confessional word of the accused to him. So also my father told me and others about the occurrence. Before her, he had made an extrajudicial confession. PW1 is an eyewitness, my lord. PW6 is a doctor who had told about the injuries which are sustained, my lord. There's a recovery had been done at the instance of the accused, my lord, leading to recovery of that my lord, stone and the lathi. And PW11 is the person who had recorded the confessional statement of the accused, my lord. There also in the confession statement, he has told about the entire incident. PW1, 2, and
the present appeal is directed against the judgment dated 21st September 2001, passed by the additional sessions judge Rai Rangpur, District Mayurbhanj, in ST case number 11 by 64 of 2001, convicting the petitioner for the offence under section 302 IPC and sentencing him to imprisonment for life. The case of the prosecution on 19th October 2000 at around 7 a.m. The deceased Kini Beva went to the Bargimara field to tend to cows. Her son Jagabandhu Nayak, bracket PW1, went to Hatabadada to bring some medicines as he was suffering from malaria. He states that at around 2 p.m., as he was going to returning to village Bargimara, on the way near village Jodapokari in a field, he found his mother and the accused Kama, who happened to be his elder brother's son, bracket, tending to the cattle. He then saw the accused suddenly deal lathi blows on the body of the deceased Kini Beva, by which she fell down. Thereafter, the accused dealt stone blows on the head of the deceased. Full stop. PW1 states that he saw the occurrence from a distance of 20 feet. Full stop. He objected to the assault, but the accused chased him, and out of fear, PW1 ran away to the village through a different route and disclosed the occurrence to his daughter Anita, bracket PW2, and son Ashok. So thereafter, he disclosed the incident to other villagers. Hearing about the occurrence, the witnesses went back to the spot and found Kiri Beva lying dead. PW2, the daughter of PW1, told them about the extrajudicial confession made by the accused to her that he had killed the deceased. Stop. Paragraph. PW1 has disclosed that prior to the quarrel, prior to the occurrence, there had been a quarrel between the deceased and the accused for landed properties. Stop. The affair was registered on 19th October 2000 for the offence under Section 302 IPC. Stop. The accused was arrested on 20th October 2000. Stop. On his statement, the stones and the lathi used in the commission of the crime were recovered. Paragraph. The postmortem of the deceased was conducted by Dr. Durga Mahesh Das. Durga Madhav Das. He found the following external injuries on the dead body. Take from page 39. 3 injuries. On dissection of the brain, the cavity was found full of blood. So the brain matter corresponding to injury 3 was pierced with bone pieces. There was fracture of the right parietal bone found with extradural hematoma. The cause of the death was due to shock out of hemorrhage on account of the injuries. In cross-examination, PW5 confirmed that, open quotation, the injuries cannot be caused if anyone will fall on a stony place. Unquote. He confirmed that the lathi shown to him could have caused the injuries. Eleven witnesses were examined for the prosecution. There was one defense witness, Bhagirathi Naik, bracket DW1. The trial court on the analysis of the evidence found the testimony of BW1 to be trustworthy and consistent. The confession made by the accused to PW2 was also viewed by the trial court as being true, voluntary, and free. The recovery of the weapons of offense was also believed by the trial court. The accused examined himself as DW1. What is he written in that? Let's see that.
Weekly list item number 3.
Your Lordship, weekly item number 3, Your Lordship, I would like to call for a report whether the appellant is alive or not. Despite directions from this court, we have not in touch with the appellant, Your Lordship. It's audible.
Ms. Patnaik, are you for the state?
My lord, yes.
No report from the IAC?
No, my lord, we have not received.
All right. There is a report. He's present at his house. Yeah, the report is that he's present.
Present in his house, Your Lordship, but that was in 21, Your Lordship. Subsequently, we got to hear that he has become the patient, Your Lordship.
What patient?
Patient of paralysis, Your Lordship. He's
That's
unable
all right.
to. Yes, also, we are not able to take material instructions from him regarding.
No. You'll have to proceed with the matter. Sorry. Please proceed with the matter.
Your Lordship, on that occasion, Your Lordship may give me one last chance, Your Lordship.
No. It's a 2002 matter. Madam, you'll have to proceed with the matter.
Your Lordship,
All appeals can't be adjourned like this. Yes.
No, Your Lordship may give me one last chance, Your Lordship. I'm only seeking an adjournment because despite the directions from this court, the client has, the appellant never tried to contact us, and we got to know that he has become a patient of paralysis. So whether he is alive or dead also, Your Lordship, that we do not know as of yet, Your Lordship. That was the only ground I had sought.
There's no need to presume that he's dead. Unless there's a report, we can't presume he's dead, please.
Your Lordship may mandate his presence in the court or else.
No, why should we? That's not necessary for that. It's only when nobody's appearing for him that we do all that. When somebody is
Yes,
appearing, we don't insist on the presence of the.
for him, Your Lordship, but we do not know because he has been out of contact since the time after.
It is bound to happen. All these are 20-year-old appeals. This is bound to happen.
Your
See,
Lordship,
we publish the list of final hearing matters in the beginning of the month.
Your Lordship,
So there's
this is-
sufficient time for people to go and get in touch.
Yes,
Sufficient
Your Lordship,
time.
I agree to that. I am also agreeing that, Your Lordship, I have personally written him several letters.
It's all
also,
right,
Your
but one has
Lordship.
to carry on with the case now.
Your Lordship, may give me one last chance, Your Lordship. Next week, after the vacation, one last chance, Your Lordship.
Everybody, today's every Thursday is the adjournment day. Nobody, I'm literally saying nobody wants to argue a criminal appeal. Nobody.
Your Lordship, that is
Only
not
because the amicus appointed by us are legal aid counsel, they're arguing. No private counsel wants to argue any case.
No, Your Lordship, this is the first time I'm seeking an adjournment before Your Lordship. I never seek an adjournment before Your Lordship.
All right. I don't know what that means now. Are we supposed to? One adjournment, minimum entitlement is one adjournment. All right, Ms. Bini Mishra, Leonard
No,
Counsel for the appellant seeks one last chance to get ready with the arguments. At your request list on 30th June. All right. All right.
Wiki list item number 4.
For your Lordship, I was engaged as amicus curiae.
Yes, yes.
Lordship, kindly have a glance to the paper book. There are two, Your Lordship.
Yes.
The long and short prosecution case is that the deceased was residing in a apartment with his family in Shantinagar, Bhubaneswar. The accused is a resident of Banki Mohana, Puri town, was often visiting the Shantinagar and befriended with the deceased. In the midnight of 16/17/1999, at about 1:45 a.m., the accused came to the house of the deceased at Shantinagar, awakened him from the sleep, and challenged him, the deceased, for stealing his accused pudia, dropped work in a paper. As the deceased pleaded ignorance, the accused asked him to state an oath before the deity in the nearby Trinatha temple. They went to the road in front of the Trinatha temple. While the deceased was taking oath, the accused wiped away a knife from his pocket and slitted the right side neck of the throat and ran away to that railway track and made good his escape. The deceased, who fell down unconscious with a deep, long wound on the neck, was rushed to Capital Hospital, Bhubaneswar, where from he was referred to SC Medical College Hospital, Cuttack. He succumbed to the injury at 11 p.m. on 17/5/99 while receiving treatment in ENT ward of SCB Medical College and Hospital. The wife of the deceased, PW5, lost a affair in Karbalnagar police station soon after the occurrence at 2:15 a.m. on 17/5/99, whereupon the Karbalnagar police station case number 134 of 99 under section 307 was registered. Consequent upon the death of the deceased, the case turned to 302 of IPC. In due course of charge sheet was submitted under section 302 of IPC was submitted against the accused. The accused took plea of verifying from denial, alibi, and scuffle between him and the deceased, in course of which the knife held by him deceased accidentally struck the neck of the deceased. He has adduced defense. The son of the deceased, PW6, carried the deceased to the casualty department of the Capital Hospital, Bhubaneswar, by trolley rickshaw. A PW through soon after the occurrence, the deceased was immediately rushed to the operation theatre of the hospital, where Dr. Vijay Kumar Sahu, assistant surgeon of the hospital, PW10, opened up the wound, cleaned it out by giving pressure pack, and referred the deceased to the SC Medical College and Hospital, Cuttack. The doctor, PW10, has reported the deceased has bleeding incised wound on the neck, but he was conscious, and on the requisition of IO, he recorded the dying declaration of the deceased, Exhibit 13, and the operation theatre at the operation theatre, in course of which the deceased has stated that the Sridhar Das, the accused, had inflicted the wound on the neck by means of a knife. On being referred to SC Medical College and Hospital, Cuttack, the deceased was admitted to the ENT department at 7:30 a.m. on 17/5/99. The assistant professor of the department ENT who attended the deceased found inside wood about 6 inch long, beginning from anterior midline of the level of upper border of
Yes.
6 inch long, beginning from the anterior midline of the level of upper border thyroid cartilages along with the right side of the neck, and the deceased about 6 inch into the lateral side of the neck, about 2 inch from the vertebral column with injury internal jugular vein. He PW8 repaired the injury by cut, but the deceased succumbed to the injury at 11 while receiving the treatment in ENT department. Here, Lordship kindly see 1, 2, 5, and 6 are the ocular witness to the incident. 1 and 2 are the independent eyewitness. 5 is the widow of the deceased, and 6 is the son of the deceased.
Let's read 1, PW1.
Well, PW1, your Lordship, for 43, your Lordship.
Page 43.
I know the accused in the dock and the deceased Akhya alias Akhivari. Akhi is the resident at Santinagar near my house and visiting our house at times. The occurrence took place about 2 years and 2 months back in the midnight of the road running from the site to my house near Trinatha Mandir. It was a summer night and I slept on the trolley kept in front of the house. The deceased Akhivari on the road came to the road near Trinatha temple and stood below the light post. I was not asleep then. The accused was deceased Akhya. The accused asked deceased to speak on the name of God, Ranokha. Thereafter, the accused wiped out a knife from the bag and carrying and slitting the cut right side of the throat of the neck of the deceased Akhi. The accused then ran away towards railway track. The deceased sat on the road holding his neck and throat. The wife of the deceased and the Sahi people came to the spot and lifted the deceased to the house situated very close to the place of occurrence. Being frightened, I did not go to the near to the deceased. I do not suffer from the cross-examination, Your Lordship. I do not suffer from impaired vision. I never use spec. It was a Sunday night. I am residing at Santinagar for last 15 years. I have visited the police station once after the occurrence. The police served me someone about 3 days back at my house. It is not a fact that I was called to the police station. There is 3 light posts in my street. I do not recollect if it was a dark fortnight or bright fortnight. I had not taken electricity connection to my house at the time of occurrence. The Trinath temple is adjacent to the boundary wall of FCA Godown. There are 2 sides of lanes and the narrow lanes in the street. Tubu Visoi runs retail shop in the cabin in front of my house. I cannot say if other inhabitants of the street had taken power connection into their house. I had slept in the trolley rickshaw from 8 p.m. in the evening, but I had not sound sleep. I am a liquor addict. I do not remember who is the owner of the trolley I had slept on. My house is at the house of deceased was intervened by a lane. The road runs from left of my house. The house of
Madhav Reddy adjoins to the right side of the house. The deceased had his house behind my house. I do not recollect the name of the in front door of neighbor. I had normal relationship with the deceased and accused. I cannot say who anybody else had seen the accused cutting the neck and throat of the deceased Akhi. The occurrence took place at a distance of 10 feet from the trolley which I was sleeping, whereas other trolleys at a distance of 20 feet from the trolley which I had slept. Some people were sleeping on the trolleys. The boundary wall of FCI Godown was at a distance of 25 to 30 feet from the trolley. I had slept in my house at the first house from the place of occurrence. I cannot say if the deceased and the accused seen me sleeping on the trolley or not. I had not raised any alarm as the accused cut the neck of the deceased. Half an hour after the occurrence, I wait inside my house. I had not accompanied the deceased to the hospital. From the capital hospital to deceased are referred to SCB Medical College and Hospital, Cuttack, where the deceased succumbed to the injury. The dead body of the deceased was cremated in Bhubaneswar 2 days after the occurrence. It is not a fact that I have not witnessed the occurrence. It is not a fact that I am deposing falsehood at the instance of police. It is not a fact that I am looking after the household affairs of the deceased after his death. It is not a fact that I am deposing falsehood at the instance of widow of the deceased. It is not a fact that there was no light post on the street. This is PW1, Your Lordship. There are other witness, PW2, 5 is the widow and 6 is the son. And there is also dying declaration recorded by PW10, who is the doctor, Your Lordship.
The dying declaration?
Dying declaration was recorded by PW10, Your Lordship.
Let's see that.
I have
Page
been
74.
Page 74. I have been posted as Assistant Surgeon, Capital Hospital, Unit 6, Bhubaneswar since May 1919 and continuing at 2:30 a.m. at 17/5/99 as on duty of male surgery ward at the Capital Hospital, where the patient Akhi Barik was admitted in male surgery on being referred by casualty department. The patient was bleeding insideward in his neck, but he was conscious state and bleeding profusely. Again says the patient was sent to the operation theater from the casualty and I was on duty in operation theater. I, with the help of anesthetic, opened the wound, cleaned up and gave pressure pack on the wound, referred the case to the SC Medical College Hospital, Cuttack. In the meantime, I got requisition from IU to record dying declaration on the patient. While I was cleaning up the wound, the patient is in OT. Again, since I recorded the dying declaration of the patient on the OT before opening the wound at about 3 a.m., the dying declaration was recorded in presence of IU Brundaman Ghadi, the SI of police. I recorded the dying declaration in the question answer form. The patient told me that Sridhara Das has inflicted the injury on his neck by means of knife at the crossing about 1.5 hours before recording the dying declaration. I put questions in Odia. The patient gave answer in Odia. I recorded the dying declaration in verbatim. I read over the answer given to the patient to him. Exhibit 13 is the dying declaration recorded by me. Exhibit 13 is my signature. I took LTI of the patient of the dying declaration, which I attested. Exhibit 13/2 is the LTI of the patient along with my endorsement. Exhibit 13/2 is the signature of SI Brundaman Ghadi. Exhibit 14 is the bedded ticket, 2 seats of patients. Exhibit 15 is the
all this we need not read. What is the cross-examination?
The wound of the patient was bandaged by casualty department, but he was receiving.
He was received while
bleeding from the wound in spite of bandage. I have written the question and answer in Odia. Exhibit 13 is my handwriting in English, and its heading in English is written by Dr. Saroj Chandra Mishra, an anesthetic, who is assistant to me in the OT. The anesthetic went to prepare the anesthetic drugs and was not present at the time.
Anyway, so what is your argument, sir? Tell us. We have eyewitness, dying declaration, doctor's evidence, everything is there.
Well, at PW 5 and 6 are the relative eyewitness to the.
It's okay. I think whatever we read is more than enough. You have to attack these
witnesses. And PW 1 is a alcoholic, Your Lordship.
So what?
So their evidence should be given, should be given much more cautions while dealing with your lordship. And PW6 10 while
why would an alcoholic speak untruth unless he's in a drunken state when he saw the evidence? I mean, event.
And PW10
is it your suggestion that he was drunk when the incident happened?
Well, that suggestion was not given.
So let's stop it at that.
Well, it is a poor person could not afford a lawyer. The trial was conducted by SDC.
Whatever, sir, that is not the point. We just go by whatever is there. We have to go by whatever is there, right?
Well, I cannot improve upon the...
No, you cannot. What is your argument? Given this evidence, what is your argument?
Well, PW10, who is the doctor who conducted the dying declaration, he was not endorsed upon the dying declaration form that he was a fit state of mind to give an question and answers, your lordship.
No, which is why he's cross-examined, right? He's asked repeatedly, could you hear the accused? Was he making sense?
The PW says when he was taken to hospital, he was unconscious.
Right.
But the doctor says he was conscious.
At the time.
At the time.
Because the doctor was able to use cat gut, repair the wound. Low voice, correct.
And there is no recovery of weapon from the accused.
Is that relevant? When there's an eyewitness and there's a dying declaration, does it make a difference that the weapon is not recovered?
My last argument, your lordship, he remained inside custody for over 10 years. So, your lordship, there is a decision of Honorable Supreme Court in this slide. Your lordship, it is 1983 Supreme Court 284, your lordship. Section 300 and para 3, 302, 304 para part 2, your lordship. Murder, intention, solitary. Here it's a one blow, your lordship.
No blow, it's on the neck. It's a cut wound on the neck.
Here in this case, here also in the chest, your lordship. One blow in the chest. In this, in the decision.
No. First of all, there is no question of a grave and sudden provocation at all.
Well, there is a quarrel between them. Because
and then they go to the temple.
Both of
it's
them.
Not then and there. So then they go to the temple. He's armed with a knife. The other man doesn't have anything.
Well, here
and even before he can make a confession in front of the deity, this man whips out the knife
from behind.
So no provocation at all.
Well, here also solitary blow on the knife.
No, that's not the only criteria, sir. That's not the only criteria.
Well, in the decision also, there is no provocation from the knife, but only on the basis of that, there was a one blow and there is no intention to kill. There is a knowledge that so under 304.
No, here you can't argue no intention. See, there is a gap between when he accused him of stealing his pudia and when he goes to the temple.
Of 5 minutes, your lordship. 5 minutes, your lordship. The temple is 5
there's
minutes.
A gap. That's 5 minutes is a long time.
Just 35 cubits from his house, your lordship.
No, you can't say it was not pre-planned. He goes with a knife, accompanies him to the temple, and he actually misleads him. That man is thinking that he is supposed to confess to whether or not he took the pudia. And before he could even say anything, this man pulls out the knife.
Here, your lordship, no attempt was given to give a second blow.
He's slit the neck, so he knows.
Here, my lordship, kindly have a glance to the decision. Deceased is a part to the deceased is not part to the quarrel. No attempt to inflict second blow. Blow was on the chest, proving fatal. Intention to cause a particular injury cannot be attributed to accused. Conviction
what you're not reading is what led to the offense. Just let's.
This is a small quarrel, your lordship. In this decision, there is a small quarrel between, but deceased was not part to the quarrel. The accused came.
So that's a very different. So it happened then and there. He is not even the intended target. X is fighting with Y. A runs in between and gets killed. So that's a classic 304 situation.
304. I think your lordship can convert it 304 part 2, your lordship.
For what? None of the
I don't have the intention to kill.
The ingredients must be fulfilled for that. This is not a grave and sudden provocation at all.
He was carrying a knife.
No, and the other man has no provocation. I can understand if the other man is armed, the other man say abuse this man, something, nothing. The accused alleges that the deceased stole. The accused then takes him to the temple. There, the accused pulls out a knife and kills him.
Here, your lordship, also the quarrel happened in the morning and the blow was given in the night.
See, all that is no. Quarrel happened in the morning.
Yes, your lordship.
No.
My lord, in this decision, your lordship.
The judgment. But the intended target was not the deceased at all in that judgment. What is the citation of that judgment and give the cost?
Your lordship, 1983 Supreme Court, page 284. Jawaharlal and another appellant versus State of Punjab respondent. May I read the important paras, your lordship? There's 2-3 paras, your lordship.
No. The main para is when this man intervened, right, in the quarrel. The deceased intervened in the quarrel.
No, he did not intervene, your lordship. The appellant, who is the brother, along with their father, Sridharalal, was prosecuted for the offence under section 302, read with 34, section 324 of the Indian Penal Code. Prosecution case is that the appellant have a sweetmeat shop at Katra, Amritsar. PW6 Amrik Singh is residing in a house opposite the shop. On April 13, 1980, Sardari Lal, the father of the appellant, requested Amrik Singh to permit him to tie up a rope canpoy with the projection of the house of the witness, but he did not allow the same. Sridhar Lal was offended. On April 18, 1980, the wet underwear drying off in the roof flew away from and picked out by the first appellant, Jawaharlal. But when the witness Amrik demanded the same, the appellant had declined to return the same, saying that he had found the same lying in the bazaar and moreover, he had not followed his father to tie up the road. There was an exchange of abuse, but the matter ended there. In the evening, on that date when Sardari Lal visited the shop of the appellant, Amrik Singh complained that the conduct of first appellant, Jawaharlal Lal. However, Sardari Lal persuaded the first appellant to return the underwear to the witness Amrik Singh. At about 9 p.m. on the date, the deceased Darshan Singh, accompanied by PW,
so Darshan Singh is not connected with this
visited the house of the witness Amrik Singh, setting the details of marriage, and there was performed in the near future. At about 10 p.m., the deceased Darshan Singh and the PW Santosh Singh left the house of the witness Amrik Singh. Amrik Singh followed them. When they reached the Bazaar locality, all three of them saw two appellants, Sardari Lal standing in the front of the shop. Seeing the deceased Darshan Singh in his companion, they raised charges. Sardari Lal raised Lal Kras and exhorted the appellant to catch hold of the witness Amrit Singh. He should not be allowed to escape. It is alleged that the appellant number 1 and 2, each of them armed with a dagger. The first appellant, Jawaharlal, gave a blow to the dagger on the left side of the chest of the deceased Darshan Singh, who fell down on the ground.
So the main target was Amrik Singh.
Yes, your lordship.
So Darshan Singh just happened to be there and he got attacked. That's all right. The present appeal is directed against the judgment date 32/2002. It's case number 171 of 2000. Convicting the appellant, the offense and punishable at 302 and sentencing him to imprisonment for life. Dependency is the present appeal. By an order dated 13th February 2009. 13 July 2009. This court enlarged the appellant on bail. This court has heard the submissions of the counsel to the parties. The case of the prosecution is that the deceased was residing in a hutment with his family at Shantinagar in Bhubaneswar. Stop. The deceased was a resident of Puri town and was often visiting Shantinagar. Stop. He befriended the deceased. Paragraph. At 1:45 a.m. on the intervening night of 16th/17th May 1999, the accused came to the house of the deceased, awoke him from a sleep, and challenged the deceased by accusing him of stealing the pudia bracket drugs wrapped in paper bracket of the accused. Stop. The deceased pleaded ignorance. Stop. Thereupon, the accused asked the deceased to state on oath before the deity in the Trinath temple nearby. Stop. Both the accused and the deceased then went in front of the Trinath temple. Full stop. While the deceased was taking oath, the accused whipped out a knife from his pocket and slit the right side neck from the throat of the deceased. Full stop. The accused then ran away towards the railway track. Full stop. Paragraph. The deceased fell down unconscious with a deep, long wound on the neck. Full stop. He was rushed to the capital hospital, Bhubaneswar, and from there was referred to the SCB Medical College and Hospital, Cuttack. Paragraph. The deceased succumbed to his injury at 11 a.m. on 17th May 1999 while receiving treatment at the SCB Medical College and Hospital. Full stop. The wife of the deceased, bracket PW5, lodged an FIR at the Karavala Nagar police station at around 2:15 a.m. on 17th May 1999. Full stop. Initially, the FIR was registered under Section 307 IPC, and after the death of the deceased, converted to 302 IPC. Full stop. It appears that the deceased was rushed to an operation theatre where Dr. Vijay Kumar Sahu, bracket PW10, treated him and then referred him to the SCB Medical College. PW10 also recorded the dying declaration of the deceased, bracket Exhibit 13, at the operation theatre, where the deceased named the present accused as having inflicted the knife wound on his neck. PW8, the doctor who treated the accused at the SCB Medical College, sought to repair the injury by cat gut. Full stop. However, while receiving treatment, the deceased succumbed to the injury at around 11 a.m. on 17th May 1999. Paragraph. The same doctor, PW9, conducted the postmortem of the deceased. and he noticed the following injuries. Take from page 72 of the paper book, 1 to 4. Injury number 1 was opined to be sufficient in the ordinary course of nature to cause death. Apart from the above evidence, there was the evidence of the eyewitness.
5 and 6.
Srinivas Naidu, packet PW1. The trial court, on analyzing the evidence, was satisfied that the prosecution had proved the case against the appellant beyond all reasonable doubt for the offence punishable in section 302 IPC. Stop the trial court proceeded by the impugned judgment to convict the appellant for the aforementioned offence and sentence him to life imprisonment. Paragraph. This court has certainly counsel for the parties and has been taken through the evidence on record. Paragraph. The first submission of learned counsel for the appellant is that PW1 was admittedly an alcoholic and his evidence had to be treated with great caution. Full stop. The court has carefully perused the evidence of deposition of PW1. At the relevant time, he was sleeping on the trolley rickshaw in the street in front of his house next to the Trinath temple. Full stop. He witnessed the accused take the deceased to the crossing near the temple. And he witnessed the accused slit the throat of the deceased with a knife and then run away. Stop. No doubt, PW1 admitted in his examination chief that he was an alcoholic, but there was no suggestion put to him that he was in a drunken state when the incident happened, or that because of his drunkenness, he was not able to correctly appreciate what he was witnessing. So therefore, it is futile to contend that because PW1 happens to be alcoholic, he should be disbelieved. Full stop. On the contrary, PW1 gave clear and cogent answers in his cross-examination. And there was not a single answer elicited by the defense which could discredit his testimony. Full stop. He appears to be a natural and chance witness who had no axe to grind as far as the accused is concerned. Stop. Paragraph. PW10, the doctor who recorded the dying declaration of the deceased, also has spoken very clearly about what he recorded. In the form of a dying declaration. Stop. He in fact read it over and explained to the deceased in Orissa and got it confirmed by him. Stop. The deceased was very categorical in his dying declaration that he was attacked by the accused with a knife. Stop. Again, PW10 was subject to cross-examination, but nothing substantial emerged therein to discredit his testimony. Stop. There's no answer therein which would even remotely assist the case of the appellant. In the considered view of the court, the above two pieces of evidence, that is PW1 and PW10, are more than sufficient to bring home the guilt of the accused. Paragraph. Learned counsel for the appellant sought to argue that the weapon of offense was not recovered and that there was absolutely no motive for the crime at all. Stop. Relying on the judgment in Jawaharlal vs. State of Punjab, AR 1983 SC 284, he argued that at best this could be a case of culpable homicide not amounting to murder, punishable under Part 2 of Section 304 IPC. Full stop. Paragraph. The court is unable to agree with the above submission. Full stop. This was not a case of grave and sudden provocation at all. Full stop. As the facts reveal, the accused alleged that the deceased had stolen his single quotes pudia. Semicolon. The accused then insisted on the deceased going with him to the Trinath temple to take an oath there. Semicolon. While the deceased, unarmed, was taking such oath, the accused, who had come prepared with a knife, whipped it out and slit the throat of the accused. Full stop. This was clearly pre-planned and not at the spur of the moment. Paragraph. Although it was argued that the fatal wound was a single wound and that the deceased succumbed to it only the following day at around 11 a.m. while undergoing treatment, the fact remains that it was on the vital part of the body and with a deadly weapon, whereas the deceased was totally unarmed and defenseless. Full stop. The facts in Jawaharlal indicate that the deceased in that case was not the intended target of the accused at all. Full stop. The facts reveal that it was one Amrik Singh who was getting pinned down by the accused for being murdered, and the deceased happened to be accompanying him, and got killed in the bargain. Full stop. Therefore, the killing of the deceased, that is Darshan Singh in that case, was not a planned killing at all. Full stop. On the other hand, in the case on hand, the accused came prepared with a knife, intending to kill the accused. And that is how, after falsely accusing him of stealing his pudia and taking him to the temple, while the deceased was in the process of taking oath, the accused pulled out his knife in a flash and slit the throat of the deceased. Full stop. Consequently, the court is not satisfied that the ingredients of either 304 Part 1 or Part 2 stand fulfilled in the present case. Full stop. In other words, it is not open to the accused to plead that the case is one of culpable homicide not amounting to murder, and that there was no intention to cause death to the deceased. Paragraph. The court is satisfied that the trial court has committed no error in holding that the prosecution has proved the case against the accused beyond all reasonable doubt. The trial court judgment does not call for any interference. The appeal is accordingly dismissed. The bail bond of the accused is cancelled. He is directed to surrender forthwith at any event not later than 31st May 2022. If he fails to do so, the IIC of the concerned police station will take steps to have him taken into custody in order to serve out the remainder of the sentence. The appeal is dismissed in the above terms. No orders to cause.
Weekly list item number 5.
Whereabouts? So, appellant is hale and healthy. None appears for the appellant. The police report is that he is hale and healthy. Stop. The appellant is presently out on bail. Paragraph. Notice without process fee through the concerned IIC to the IIC of the concerned police station be served on the appellant to remain present in court on the next date. Meanwhile, the registry will supply one complete set of the paper books to the Secretary of Orissa High Court Legal Services Committee, who in turn will entrust them to a panel counsel of not less than 10 years experience to appear for the appellant. The said assigned counsel will get in touch with the appellant for instructions.
May I submit one thing?
Yes.
In 5 and 6, the leading counsel for the appellants is dead since the last 10 years. So appropriately notice should be issued to the appellants to engage counsel of their choice.
No, so we are issuing notice to them. Meanwhile, we are also giving them the chance of a legal aid counsel.
Is aware of the fact that the counsel for appellants is dead. She should have said so.
No, this already happened in the previous order. The previous order has already recorded all this, and that the appellant should be informed of the death of the counsel. All that has happened. You see the list on 7th July.
Item 6. May I please, yours?
Yes.
This case, my lord, notice due to serve on the appellants, my lord. Thereafter, they engage me email in this.
All right.
This case, my lord, PW1 is the informant, my lord.
Yes.
One Kailash Chandra Barik, my lord.
Right.
Sunari Barik is the deceased. My lord, died on 1996, my lord. At the evening time, my lord, I received a telephonic call, my lord. Thereafter, he made statutory entry. On the next day, he visited the spot, my lord. And there the petitioner, PW1, lodged the information before the IIC. Accordingly, the case was registered, my lord, and the investigation carried out, my lord. The case, my lord, there are all total 7 witnesses has been examined by the prosecution, my lord. And so far the FIR, my lord, at page 23, my lord, FIR lodged by PW1, my lord, FIR registered against unknown persons, my lord. The PW1, though the brother of deceased, he has not whispered a single word in the FIR against any of the accused persons. Accordingly, FIR registered against unknown persons, my lord. Under the trial court, my lord, taking into consideration the 161 statement and also the 164 statement of the PW1 and 2, and so also the IOS evidence, PW7 evidence, my lord, convicted the appellants, my lord. In this case, my lord, admittedly there is no eyewitness to occurrence. None of the witnesses supported the case, my lord.
Yes.
They became hostile, my lord.
PW1 turned hostile.
My lord. PW1, my lord, at page, my lord, 23, my lord.
Correct.
My lord, I am placing the relevant person.
Right.
My lord, PW2 at page PW1, my lord, page 43, my lord. In examination chief, my lord, paragraph 4.
No, you start from para 3 itself.
Para 3. About 6 years back, this incident took place. I was at home. Suddenly, we had a hula coming out of the house. I went outside and found my brother lying with cut injuries on his head, chest, and neck. I reported the matter in a writing at the PS. Exhibit 1 is the said affair. Exhibit 1 by 1 is my signature therein. I cannot say how my brother died, and also I cannot say who killed him, my lord. This is very important, my lord. And thereafter, the declared hostile, my lord, the prosecution examined him, my lord. Likewise, my lord, PW2, my lord, another brother of the deceased, my lord, he stated, paragraph 2, deceased victim.
No, why don't we read the cross-examination?
My lord, my lord, cross-examination, my lord, by the additional PP. I had stated before the police, it is not a fact that I had stated before the police that I had seen Saroj Khuntia and his brother Manas Khuntia returning from the spot of occurrence. It is a fact that there was an earlier dispute between my deceased brother, victim, and the accused persons for my brother setting one house on fire. It is a fact that that in connection with the incident, we had moving Honorable High Court, and Honorable High Court in this case directed a recording of our statement under section 164 CRPC. I do not remember if I stated during my section 164 CRPC statement that the accused Mahesh Manas by means of a Gupti weapon of offense tried purse through the neck of my deceased brother and accused Naresh.
Pierce through the neck.
My lord, pierce the neck of my deceased brother and accused Naresh Khuntia was giving bhujali blow on him. At that time, accused Manas and accused Saroj has holding both his hands. It is not a fact that being gained over by the accused persons, now I am hiding the truth, facts and deposing falsely. Defense, my lord. A cross-examination by defense. My brother was lying dead 300 to 400 meters away from the house and it was a dark night. 2 years prior to the incident, deceased Sunari was not staying in our house. Even on the date of occurrence, he did not visit our house. I did not telephone to the PS, intimating them the incident. The next day of the occurrence, I lodged the FIR, writing in the FIR myself. The entire night after the occurrence, none stayed watching the dead body of the victim. And dog tracking squad was brought, but the dog failed to indicate anything. Whosoever in our village goes to river bank and he or she was to pass in front of our house, even the accused persons have to pass in front of our house for going to river bank. All the villagers in our village, or they are bathing or attending call of nature, usually depend on the river. My brother was lying dead near the bank of river. By the time I reached the spot, about 15-60 persons had already assembled. On the very day of my FIR, my statement were recorded by police. So also my family members. Since because on our FIR, the PS case did not progress, leading to submission of a charge sheet, we moved the Honorable Court in a miscase for recording our statement under Section 164 CRPC. And our statement under Section 164 CRPC was ditto of what was tutored by police. My lord, tutored by the police. Murali alias Umakanta Barik is my cousin, being the son of my father's elder brother. After this incident, we had left the village with his family. He left the village with his family. His whereabouts not known. In our village, there are 4,000 to 5,000 inhabitants. I cannot say who set in fire the house of the accused persons. But interesting thing, my lord, thereafter, my lord, re-examination of the witness under Section 138 of Indian Evidence Act, since witness was found present in the court on 9/1/2003, my lord. Neither the PW1 summoned, he was present in the court and the court asked some question to him, my lord. Question number 1. You stated yesterday during cross-examination that there was earlier dispute between you, your deceased brother, victim, and the accused person standing on dock for setting a house on fire. Answer. My deceased brother was staying outside our house 2 years prior to the incident, and I heard that said brother had set a house on fire. I heard, my lord. Question number 2. Was the deceased your own brother, natural born? The witness, answer, the witness nod his head and says it affirmatively, yes. Question number 3. Why your said brother who had murdered, staying outside your house for the preceding 2 years? Answers. Since he was not doing anything and my father was abusing him, he was staying outside. Question number 4. Your father examined.
Was your father?
Not a visual man in my police paper book. Yes, your father was examined by the police in connection with this case? No. Was your father available in your village at the time of incident? Yes. Can you assign any reason as to why father was not examined by police when one of his son was murdered? I cannot say. Did you feel sorry at the death of one of your brother? Yes, we felt sorry. Is it that the murder took place in the evening? Yes, it took place at about 9:30 p.m. night. How far from your house was the spot of murder? 300 to 400 meters away from our house. Is it that the entire night of occurrence, the dead body of your deceased brother lying unattended at the spot, though hardly 300 to 400 meters away? Yes. Is it that in connection with this case, police summoned you to PS? Yes. Is it that you are also detained at PS for 70 to 8 days?
7 to 8 days.
7 to 8 days. No, I was not detained, but my brother, namely Kailash Chandra Barik, who is the son of my father's elder brother, PW 3. Umakant Barik and sister Bimala Barik, who is the daughter of my father's elder brother, were detained in connection with this case, my lord. That is all about the Pidul 1, my lord. Likewise, my lord, Pidul 2 is the another brother, my lord.
No, so what does he say in the 164?
My lord, 164, that is, my lord, page
64.
64, but written in Oriya, my lord.
Yes. He must be saying it is the accused who killed him.
My lord,
Yes, he has implicated all the accused.
My lord, time to that, though this petition, the witness, my lord, Pidolu, are not stated anything in the affair, my lord, subsequently developed somehow in his 161 statement and 164 statement. And he specifically categorically stated before, while giving evidence in the court, my lord, he being tutored by the police is deposed under 164 statement, my lord. And Pidol 2 also, another brother, whose 164 statement recorded by the magistrate, my lord, he categorically stated that being tutored by the police.
Let's see PW2.
My lord, Pidol 2.
Virtually the same thing.
My lord?
It's the same thing, PW2 also.
Pidol 2, my lord.
Page 66.
Page 48, my lord. Evidence, my lord. 48. Yes. I know all the accused persons standing in dock. This is victim. Sunari is my younger brother and he died 19 July, but I cannot say the year. I went to the spot and found he was lying dead with a bhujal blow given on the person. I cannot say how he died and who killed him. My lord, therefore he became declared hostile, my lord, and cross-examination by the additional PP. I was examined by police. I do not remember if I stated before the police that accused persons threatened to finish persons who set fire their house in fire, and that I suspect the 3 accused persons in my brother's murder case. It is a fact that my statement under section 161 CRPC was recorded before the London magistrate, but it is not a fact that I stated before the London magistrate that my brother deceased set fire to the house of the accused, and as he did not give 50,000, they murder him. It is not a fact that being gained over by the accused persons I deposed falsely today. But specifically, I stated that I cannot say how he died and who killed him, my lord. Likewise, PW 1, my lord. Cross-examination. On being instigated by police people, we moved. That is, he admitted. On being instigated by police people, we moved for recording our statement under section 164 CRPC before the court. Our statement was based strictly on the tutoring of police. Tutoring police. But Pilot 1 also stated like that, my lord. My father is alive, and besides that, deceased brother were there other deceased brother. We are 3 other brothers. By the time of incident, I was at a Chadai, which is 1.5 kilometers away from the spot. The same night, I did not visit the PS. And Pidol 3, another brother, whose 164 statement not recorded. 164 statement of Pidol 1 and 2 have been recorded by the magistrate, my lord. Here PW 3, my lord, another brother. I know all the accused persons standing in the dock. This is victim Sunari, is my father's younger brother's son. He died about 5 to 6 years back. I was away from the house. I came back, and at about 7 p.m. evening, I went towards the river bank to attend the call of nature. And by the time I came back, I had the hula and I found the victim lying dead. I cannot say who killed him.
So there was no doctor's evidence here.
Man, no doctor has not been examined. Why the doctor and prosecution not examine him? That is doubtful. That is not in the record.
So we don't know how. What was it? Strangulation, injuries. What was it?
Doctor has not been examined, and though the postmortem report, my lord, exhibited, my lord, but doctor has not been examined in this case, my lord. So also, my lord, there are, my lord, the
4, 5, 6 all hostile.
My lord, so all the witnesses become hostile, my lord. That happened, my lord. PW 4 and 5, my lord. The weapon offense has not been recovered. Though the cover of Bhujal has been recovered, my lord, the weapon offense has not been produced or not recovered. Nothing, my lord.
So how does the trial court judgment proceed?
I'll bring your lordship to page para 19, my lord.
For the trial court judgment.
Yes, ma'am. No, that is very interesting, my lord. My lord, incident happened since 1996.
No, let's read it.
Yes.
Para 19.
Regarding the 164 statement, how they were anxious to. Para 19 deals with how they were anxious for a 164 statement, which was recorded in January 1997, my lords. And this deposition is in 2003 by the time they have resigned, my lord.
Correct. So how does the trial court proceed to convict? Only by relying on the IO?
Yes, my lord. My lord, unfortunately. And my lord, 164 statement has been very clearly there. They have resigned, my lord. But as far as being hostile, my lordship knows that something which any part of the statement that
There's no part of the statement which can get rescued.
Your lordship, PW1, he states in the cross-examination that he has stated, though he had stated, he says that he had gone for a 164
Tutored.
statement.
He says it's completely tutored with the police.
My lord.
But yes, my lord, unfortunately,
both PW1 and 2. And all other witnesses have turned
yes,
hostile.
No one, only 7 witnesses are there. They're all not supported almost. Because in the 164 statement, he has specifically implicated the accused and also spoken of the dying declaration.
No, and then you've not examined
yes,
the doctor also. That's very strange. The present appeal is by 3 appellants and is directed against the judgment dated 24 January 2003 passed by the learned additional district and session judge Badrak, finding each of the appellants in ST 23/12 of 2002/1999, convicting each of the appellants for the offence punishable under section 302 IPC and sentencing each of them to undergo imprisonment for life and pay a fine of ₹10,000 in default to undergo rigorous imprisonment (RI) for 1 year each. By an order dated 10th February 2003, the appellants were directed to be enlarged on bail. Paragraph. The deceased, Sonari Barik, was the brother of Kailash Chandra Barik, bracket PW1, and Madan Mohan Barik, bracket PW2. Paragraph. The case of the prosecution is that on 19th July 1996 in the evening, Sonari Barik was murdered full stop. On the next day at around 8 a.m., the investigating officer, bracket IO, bracket PW7, visited the spot and made a station diary entry. Thereafter, the information was on the basis of the information received from PW1, an FIR was registered for the offence under Section 302 IPC. According to the prosecution, there was previous enmity between the three accused on the one hand and the deceased on the other. Arising out of the theft of a bicycle and setting a house on fire. It's claimed that the deceased was absconding in the said case involving the setting of the house on fire. Paragraph. The prosecution examined as many 7 witnesses, and barring the IO, bracket PW7, all of the others turned hostile. So, both the brothers of the deceased, that is PWs 1 and 2, PW3, son of the deceased father's elder son's brother, and PW6, a co-villager, turned hostile. The witnesses to the seizures, PWs 4 and 5, also turned hostile. Full stop. Strangely, even the doctor who conducted the postmortem was not examined by the prosecution. Paragraph. While statements of PWs 1 and 2 were recorded, under section 164 CRPC, both turned hostile in the trial and were proceeded to be cross-examined by the public prosecutor (PP). Full stop. They simply denied any knowledge of the occurrence and claimed that their statements under section 164 CRPC was also coerced and tutored and was also a coercion and they were tutored and that they were tutored by the police. Full stop. None of the other witnesses could also be made to support the case of the prosecution. None of the other witnesses supported the case of the prosecution. Except PW7, who was the IO. Paragraph. The trial court nevertheless proceeded to convict the appellants by relying on the statements made under section 161 CRPC, the confessions under section 164 CRPC, and the evidence of the IO. Paragraph. Having heard learned counsel of the parties, the court is of the view that the approach of the trial court was entirely erroneous. Stop. In the first place, reliance could not have been placed on statements under section 161 CRPC. Stop. At best, such statements can be used for confronting a witness. It can never constitute a substantive piece of evidence. Stop. Paragraph. Secondly, in a case put forth as one of a homicidal death, no attempt has been made by the prosecution to lead medical evidence by examining the doctor who conducted the postmortem for the deceased. Stop. This glaring omission has not been explained by the prosecution. Full stop. Even if the eyewitnesses had turned hostile, this is not a case where any statement made by them in the examination chief could be relied upon by the prosecution to support its case. So, on the other hand, even in the cross-examination of the hostile witnesses, what emerges is only the statements by them that they were tutored by the police. So, consequently, none of the prosecution witnesses, barring PW7, have stated anything that could even remotely help the case of the prosecution. Paragraph. The trial court also seems to have erred in relying essentially on the evidence of the IO. To stop, unless there is independent credible evidence supporting the case of the prosecution, it would be unsafe to base the conviction for an offense punishable under section 302 IPC only on the testimony of a police officer who happens to be the IO. Paragraph. For all of the aforementioned reasons, the court is unable to sustain the impugned judgment of the trial court and is accordingly set aside. The appellants are acquitted of the offences for which they were, for the offence punishable under section 302 IPC. Their bail bonds shall stand discharged. The appeal is allowed in the above terms. No orders is to pass.
Weekly list item number 7.
May I please the
Yes.
The appellant, my lord, along with his wife and paternal uncle, was facing the trial before the London court below, my lord, being charged in a case on section 302, 114, 201 of Indian Penal Code, read with 34 of Indian Penal Code, my lord. My lord, the appellant was convicted under section 302 of IPC and my lord, the co-accused were acquitted. Here, my lord, the affair was lost by the wife of the deceased. My lord, wife was examined as PW1. My lord, alleging therein on 14/8/99, my lord, one dead body of her husband, stated to be the dead body of her husband, my lord, was floating in village well. My lord, that is of oil belongs to PW3, my lord. And the body was inserted in a bag, and my lord, his hands and legs were tied by iron wire, and my lord, his legs were visible. And then, my lord, on the report of the, my lord, village, my lord, Chowkidar, my lord, the police arrived at the spot, and then the dead body was recovered. And my lord, seeing the black pant and shirt of the deceased, my lord, the dead body was stated to be identified by the wife and son, my lord. They had not gone to near the dead body because, my lord, foul smell was coming. And, my lord, the case of the prosecution, my lord, before 1.5 months back, my lord, the one Hairap festival was going on near the house of the deceased, my lord, the tribal people, my lord. And the deceased, by taking concealed liquor, my lord, Handia, my lord, he had gone to see, my lord, that dance, my lord. My lord, again he returned to home and took further Handia, and, my lord, again he went to the festival. And thereafter, he did not return to the home. In the meantime, my lord, more than 1.5 months has been elapsed. No report either by the wife, my lord, PW1, or son, who has been examined as PW7, or anybody was, my lord, reported to the police. My lord, after 1.5 months thereafter, when dead body was found at the well, my lord, affair was lost on that day, on 14, my lord, 9/99. The lordship, my lord, kindly see, my lord, the dead body was postmortem. My lord, postmortem doctor was examined by PW14, my lord. Here, my lord, my respectful submission, the cause of death was not ascertained. And in order to bring home the appellant, my lord, to convict him under section 302 of IPC, my lord, prosecution, my lord, should have proved the death is homicidal, my lord. Here, lordship, kindly see.
The doctor's evidence. Dr. Shami Salim.
PW14, my lord, page 85.
Right, let's read that.
Short. Lordship, what it 85 page. On 15/8/99, I was working as assistant surgeon at Korangia SD Hospital. On the same day at about 2 p.m., I received the dead body of Raghu Chadar. The dead body was identified by Constable number so I found as follows. It was a skeletized body. Body contained all the bones, no muscle or any other structure present on the body, no fracture of any bone present. So we sent serum and upper part of the femur for forensic examination and handed over the seized jar to the accompanying constable. Time and cause could not be ascertained for conformities. It was seized for forensic department. Exhibit 10 is my report and 10/1 is my signature. The persons or experts attached to forensic department are from the branches of medicine science. In cross-examination, I did not know the disease prior to the date of production before me. Orally, skeleton was available before me. It may be a fact that the skeleton was not belong to Raghu Chadar. And, my lord, the prosecution claims the dead body was identified as because, my lord, one pant and shirt was near the dead body. Your lordship will found that pant and shirt has not been exhibited, nor which it was produced as MO before the Lord Court bill. I was verifying the judgment, my lord. And, my lord, your lordship, kindly see.
So this is a case of circumstantial evidence, correct?
My lord, circumstantial evidence that
so
has been
the
reflected.
Homicidal death itself is not proved.
Well, homicidal death not proved, nor it has been properly identified.
let's list out all the circumstances that.
Page 32, my lord, of paper book, basing on the circumstances, conviction has been sustained.
No, I know. Let's read out what are the circumstances.
My lord, one last scene.
No, let's see. Where is that portion of the trial court judgment?
Page, my lord, 32.
Let's see that.
Para 12, my lord. I'll read it, my lord.
Right.
PW4, number 1, my lord, circumstances. PW1 has stated that her husband went away to dance by wearing a black full pant and a shirt. He did not return to the house, but after 1.5 months his dead body was recovered from the well of PW3. Number 2 circumstances, PW7, the son of the deceased said that his father has ill feeling and others kind of enmity for land dispute with accused Raibu, the appellant. Number 3, PW2 and 8 saw the deceased Raghu Chatar coming to the house of accused Raibu Chatar, and accused Raibu got threat to be cut him into pieces. My lord, here, my lord, the deceased had given the threatening. He went away to the house of accused Vijay Chatar and again returned to the house of Raibu. The deceased, being in a drunken state, again gave threat to the accused Raibu to cut into pieces. And then accused Raibu pushed him into his own house and closed the door. Number 4, these PW2 and 8 have houses very close to the house of accused Raibu. They have heard when deceased was shouting, stating that accused killing him. The hearing of such acrimonious shoutings of the deceased by PW2 and 8 are very proof of commission of murder by the accused Raibu.
So 2 and 8 become.
Number 5, my lord. According to PW12 is Raibu. Accused Raibu, being in custody, gave disclosure statement Exhibit 1 and led the police to his house and gave recovery of MO1 and 2 in presence of witnesses.
So
the star witnesses is PW2 and 8.
So let's read them.
Lord, PW8.
No, 2. PW2 first.
2, my lord. Page 57. My lord, he is a man of different locality, my lord.
Chandramohan Gagarai.
My lord. And he is, my lord, sister's husband of PW8. The both are related.
I see.
I know all the accused persons. I know the deceased Raghu Chatar. This occurrence took place since 3 years back. I had been to the house of Janki Chatar, my lord, PW8, due to Hera festival. She is my wife's elder sister. I was sitting on the veranda by taking handia. It is under intoxication, my lord, countryman liquor, local call as handia. The deceased Raghu Chatar came to the house of accused Raibu Chatar and told him to cut into pieces. Raghu again went to the house of Vijay Chatar, but no one was available in the house of Vijay. So Raghu returned to the house of Raibu again and told to cut him into pieces. Raibu pushed Raghu into his own house and Raghu shouted inside the house of Raibu, stating he was being attacked and killed. I have heard this shouting of the deceased, which was coming from the house of Raiba. I was in the house of my wife's elder sister, and it is very close to the house of Raiba. Then I went away to my own house out of fear. That is, my lord, the abnormal, my lord, conduct of a human being, my lord. Even he did not, my lord, tell to the PW8, his sister's elder sister, and my lord, where he had come and he was staying in his house. On the above, my lord, that Hera festival. He had come to see that festival. He would straight went away to his home. Thereafter, Raghu was not traced out. The dead body of Raghu was found from a well belonging to Bira by Bankara after 1.5 months of this occurrence. I have never seen the dead body of Raghu by visiting the spot.
Gap between the last scene and PW3 is living where? How far is PW3 from where this house of?
My lord, the PW3 is a co-villager, my lord. From his oil, my lord, dead body was recovered.
No, I know. But the same village as Raibu.
That, my lord, the same village of Raibu, my lord. PW3.
No, Raibu comes drunk. No, sorry. Raghu comes drunk.
Raghu comes drunk, my lord. Handia, my lord.
No. So Raibu and this PW3 are in the same village.
My lord, same village, my lord. Village Baria, my lord. But the distance, my lord, that is also prosecution as not, my lord.
So the last seen, according to PW2, of the deceased with the accused is 1.5 months ago.
1.5 months back. Some witness says 2 months back. No date and time has been, my lord, put by the prosecution. Which time, which date, my lord, nothing.
Oh.
And PW8 is, my lord, improved story.
Not to report to anyone. So why does he say he did not report to anyone?
My lord,
cross-examination.
My lord, my village, my lord, that PW2. My village Brahmasai is at a distance 1 mile from the village. My lord, he is a man of different village, my lord. No Hera festival was going in at our village. Previously, I was coming to the village of my wife's sister also. I knew deceased Raibu very well prior to occurrence. I have not attended the Hera festival, but without attending him, my lord, he had gone. I came to the house of my wife's sister during daytime at about 3 p.m. I consumed handia and I went away to my own house at evening. I never came to this village again. I heard about such shouting subsequently. I cannot say about the recovery of the dead body belonging to whom. It is not a fact that I have not heard the shouting and I am not.
What is this MO1 and 2?
My lord, MO1 and 2 is, my lord, one axe and blade, my lord. That was not used at all, my lord, in this crime. Prosecution is totally silent. No bloodstain, no serologist report. It was not shown to the doctor to show that, my lord, this weapon was used. It is stated to the weapon of offense. And it was seized from his house.
Yeah.
And leading to discovery, the witnesses have turned hostile.
Recovery witnesses have turned hostile.
My lord, 27 Indian Evidence Act, my lord, that witnesses leading to this, they have turned hostile. Nothing, my lord. And PW8, my lord, she has given improved story which has been confronted to the IO.
Let's see PW8 now.
8, my lord.
Janaki Chattar.
My lord, before, my lord, reading out that, my lord, statement, I draw the attention of a lordship. This witness is unable to speak Oriya.
Who, Janaki?
My lord, Janaki. My lord, he is, my lord, belongs to Ho community, my lord. He, my lord, she knows only tribal language.
Okay.
That is why, your lordship will found, it was interpreted by one Markonda, Ho, advocate's clerk, Koranjia. But IO claims, my lord, she is capable to speak Oriya and I recorded her statement in Oriya. PW12, my lord says. You'll also see her evidence. I know all these accused persons. I know deceased Raghu Chattar. He died since 3 years back. Hera festival was going on at our village. The husband of my sister was present at my house. Chandramohan, my lord, PW2, was present at my house. PW2 was found sitting on the veranda of my house by taking handia. My lord, he was also taking handia, that this PW2. Raghu came to the house of accused, Raiba, and gave threat to cut him into pieces.
You say it's the other way around. Raghu
Raghu is the, my lord, deceased.
Deceased, correct.
My lord, this witnesses was, my lord, under intoxication. Raghu, deceased, was also in intoxication.
Oh, yes.
But this appellant was not in intoxication. That is the case of the prosecution. My lord, I was cooking at that time. My lord, this lady was cooking. My lord, inside the house, my lord. The house of accused Raiba is close to my house. The wife of Raiba was also present in the house at that time. Raghu, by giving threat to Raibu, went away from that place. Raghu is the deceased. And again returned to that house of Raiba and again gave threat to Raibu. Then, my lord, the other parts are improvement. I will satisfy your lordship. Then Raiba pushed him to his own house and closed the door. Raghu shouted loudly twice by remaining inside the house of Raiba, stating that accused Raiba was killing him. When the shouting of the Raghu was stopped, I anticipated the death of Raghu inside the house of Raiba. My lord, this is the improved part. and it has been confronted to PW2, my lord, 12 in para 8 of which cross-examination that she has not stated earlier, my lord. That was confronted. In cross-examination, lordship kindly at a glance at cross-examination, my lord. I cannot speak or understood Odia language. For IO claims, my lord, I recorded her statement, my lord, in Odia. I gave statement to the IO in our tribal language. The Hera festival was going on near our house. During that festival, people were dancing and there are continuous beat of drums. This is important, my lord. From evening to morning, PW2 came and took his food in my house. He left the place during nightfall. My lord, he has stated, my lord, before evening he had went away. I never came out of my house during the night. The people of our village, by returning to the house, used to take food and sleep soon thereafter due to nightfall. After departure, PW2, I went to sleep. Nothing was audible due to beating of drums. How can my lord she heard that, my lord, the scream of deceased? My house is at a distance of 50 cubits from the house of Raibu. It is not a fact that I have not stated to the IO that Raghu went away from the house of Raibu and again returned to the house of Raibu and gave threat to cut him into pieces. It is not a fact that I have not stated to the IO that Raibu pushed Raghu forcibly into his house and closed the door. It is not a fact that I have not stated to the IO that I anticipated death of Raghu when his shouting were stopped. IO has also admitted, this is improvement. The wife of Raghu never came to my house to search her husband. My lord, the PW1 wife, she never, my lord, searched her husband. Husband went away, she never searched. My lord, then important line is, the wife of Raghu came to my house after 3 to 4 days of this incident.
And still nobody reported.
Nobody reported, my lord. This is very important.
And she says, I have stated nothing about the incident to the wife of Raghu.
Wife of Raghu.
That's very strange.
It is not a fact that I am deposing falsehood, so and so. Then your lordship will found that confronting my lord PW12, my lord IO. My lord IO has stated, if your lordship will allow me, I will totally read out the statement, or your lordship will para 8, my lord, the IO has stated.
Yes, yes.
In page 83, my lord.
Right.
That Janki.
Right. I do not know tribal language.
My lord, page 83, my lord, 9 lines from the bottom.
Yes.
That confronting part, my lord. PW8 Janki has not stated for me that Raghu came to the house of Raibu again and gave threat to cut Raibu into pieces, and then Raibu pushed Raghu forcibly into the house and closed the door. She has not stated for me that when shoutings of Raghu was stopped, she anticipated death of Raghu. PW8, my lord, total as she has given, my lord, improved story, my lord. Then, my lord, in cross-section para 8, my lord, first line, your lordship will found, I do not know tribal language.
Correct, correct. How did he record statement?
My lord. Right. And I have recorded the statement of Chandramohan. Chandramohan, my lord, is that PW2. Nitima is the wife of the deceased, Guru Charan and Janki prior to the arrest of the accused persons. I have not sent the statement of Nitima, Chandramohan, Janki is PW8, and Chandramohan is PW2 by forwarding the accused to the court. My lord, if these statements were in existence, my lord, the IO, why the my lord IO did not send the my lord dispatch the statement along with the accused at the time of forwarding my respectful submission before my lord, the statements were not in existence by that point of time. That is subsequently prepared, my lord, to suit the prosecution case, my lord.
Correct, correct.
I cannot assign any reason as to why I did not send the statements of Guru Charan, PW7, Guru Charan, my lord, the son of the deceased, Nitima, PW1, and Janki, my lord, PW8, and Chandramohan, PW2, while forwarding the accused person to court. I have not recorded the statement of Nitima in my own handwriting. Nitima told me PW1, my lord, say the PW1 in Oriya language. It is not a fact that Nitima does not understand Oriya language, and she never told me in Oriya. And Janki also replied me in Oriya. Janki, my lord, she does not know Oriya. And I recorded her statement. It is not a fact, she does not know Oriya. And I prepared the case to support the prosecution case. Your Lordship, Janki, my Lord, that wife of the deceased has lost affair, my Lord, not against me, my Lord, against one unknown person. And my Lord, then my Lord, the other star witnesses of the prosecution, which my Lord Court Balaji relied for warranting conviction, my Lord is PW7, son of the deceased. My Lord, he has not stated, my Lord, that my Lord, except stating that he has, my Lord, my father had ill feeling with the accused person relating to land dispute. It is an uncorroborated statement, my Lord.
Correct.
Neither wife nor any of the witnesses has stated, my Lord, that there was any land dispute, my Lord. And my Lord, they also will found, my Lord, why I am submitting, my Lord, the dead body has not been also, my Lord, identified also. One, my Lord, in one angle, my Lord, it has not been proved with homicidal death. In the other angle, my Lord, it has not been identified. My Lord, they guess it might have, my Lord, dead body of my father. My Lord, seeing the pant and shirt, my Lord, it was some witness said it was near the dead body in the well. And my Lord, some witnesses stated the full pant he had wear, my Lord, it is a skeletized body. No flesh was there. Let's see, we found PW7, my Lord, the son. The deceased Aguchatar is my father. He died since 3 years back. This witness has stated, my Lord, regarding identification. He came away from that place to my house and went away towards some place. He did not return again to the house, my Lord, the really man. We sought him for a month, but could not find him out. Chief exemption, my Lord. I came to know from village boys that dead body was found floating in the well of PW3. I informed that village. I came to the spot and found the black pant near the leg of the dead body. My Lord, that dead body was not, my Lord, owned by black pant. It was near the dead body. So I suspected. The grammar informed me in the matter at PS and police came to that place. The dead body was brought out from the well and I identified the same to that of my father. My Lord, because my Lord, the pant was near the dead body, my Lord, he has stated he suspected he may be my father. Then my Lord, in Para 2, the Lord Court below has relied that my Lord, enmity, my father had ill feeling with the accused person relating to the land dispute. That is my Lord, uncorroborated statement. He also will find in cross-examination. I got the information in the morning at 8 a.m. and by going to the spot, saw floating of the dead body. Police arrived there at 11 a.m. Villagers brought out the dead body from the well. That was near the well. I went to close to the dead body. PW1 also came to that place. The dead body was kept in a sleeping condition. Then I never went to that place. Police removed the dead body from that place. The dead body was decomposed and the flesh was detached from the skeleton. And eyes and ears and organs were damaged due to the decomposition. I guess the dead body of my father from the black pant. It is not a fact that the recovered dead body was not belongs to my father and I am depositing for fruit. This black pant and shirt, my Lord, it was not produced before the court, nor it was marked as a emoji, my Lord.
Yes.
Similarly, my Lord, wife has stated. He has
all right. Let's hear him, sir. All right.
Leading to discovery.
Let's hear the prosecution.
My Lord.
All right.
The relevant evidence in this case is evidence of PW1 and 2. And 1.8 Malat evidence of PW8. See, of course, Malat stated Malat, which is relevant.
Absurd, sir. PW8 is the most absurd.
In
the cross-examination says the Hera festival noise was so much I could hear nothing.
Yes, Malat. But so far, the evidence of PW1 and 2. One, Malat, is the wife of the deceased. She has Malat identified the dead body.
Why did she not come forward to give even a complaint, sir? Very strange this is. The husband goes missing for 1.5 months and no complaint.
No complaint was made. After recovery of the dead body, the FIR was lodged. But so far the occurrence is concerned, Malat, PW2 is the witness, Malat, who has able to see the entire occurrence, Malat, when the deceased came to the spot and challenged the accused appellant. Thereafter he went inside, then thereafter he could able to see that there was a shouting, Malat, and he was assaulting. And he in the cross-examination, nothing has been to discredit his testimony.
No, look at the gap.
That gap of 2 years, 2 months, Malat, and he has not stated anything.
And what could have happened in the gap of 2 months?
2 months.
And the body is found not in the house of the accused or anything.
It is a dead body was found from the
well of PW3.
PW3 is well from the of PW3.
So it is not from the house of the accused also.
No, PW2 has occasion to see the occurrence, but that when this deceased came to the house of PW8.
No, that's right. That at best it will only say last scene.
Last scene.
Nothing else.
Nothing else. There, of course, there is admittedly there is no eyewitness to the assault, but he has occasion to see that the accused, when the accused came to the spot, to the house of the deceased, to the appellant, he was taken inside the house and
everybody is drunk, sir. This man is also drunk.
Yes, that was there. That is the only evidence, and leading to discovery is not proved. It cannot be proved because there is no serological report is there. Only IO has recorded the confessional statement under Exhibit 1.
See that the death is homicidal, which is a very important link. That itself is not proved. Usually that is the most crucial link, the homicidal nature of the death. And this knife and whatever blade, what are the two, MO1 and 2?
MO1, that plate and knife, that is that cannot be link because that was recovered after 2 months. At his instant, that was those two witnesses turned hostile. And there is no serological report to prove that it is the weapon which is used in the commission of crime.
Correct.
So that is not, I'm lying, but the evidence of PW2 is the only relevant in this case.
All right. Then we can allow the appeal.
And PW's
the appeal is allowed. You'll get the detailed order.
Obliged.